But may I take a little indulgence? I'm told Mala, there's a criminal appeal which is likely to take a little time. There's item 15 here, hearing matter. My learned friend appears on the other side. In the afternoon, my lord, I have a privilege committee meeting. Can it be taken up on some other day?
It is. You'll be available since up to when?
And can it be on 19th of
May. Hearing item 1.5. 1.
item 15?
Okay. Any objection?
No.
Let's take it.
May I please, Your Lordship? I beg to mention item number 13 and 14. Your Lordship, Amicus Curiae is out of station. And I for the respondent number 2.
Who is the Amicus Curiae?
SV Darang.
Is for the appellant.
Yes.
Mr. SV Darang,
Miss.
London Amicus Curiae appearing for the appellant is absent by filing letter of absence. List on 0805. For orders. Number 1 or 2.
Item number 1, the question of maintainability was supposed to be.
So, my lord, here in item number 1, I want to file one editable affidavit, my lord, in connection with this PIL. So, I may be allowed to file additional affidavit, man. By placing some documents.
Second case. Second case. Okay. That has to be decided from the other Mr. Chaudhary, here the second case. WPC 136 AP 2021. The issues involved in both the this petition as well as this PIL are same, but whether the issue is whether by filing an PIL you can challenge the virus of an act or not.
That is one, and on other issues also we are questioning the main.
Now, thing is this, which one you like to take first, whether the WPC 136 or
Since in this matter, item 1, the issue of maintainability is there, that obviously has to be decided first. And once that is decided, depending on the outcome, thereafter the matter can proceed on merits.
Item number 1 is also covered in item number 2, my lord.
yes. Mr. Tazi, right? You are Mr. Tazi.
Yes, my lord.
counsel for the petitioner prays for some time to file an additional affidavit in this matter. Any objection? To which Mr. I. Chaudhary, Learned Advocate General of the state, doesn't have any objection. Mr. Chaudhary, you are assisted by whom?
Yes.
So, Commander, Senior Advocate, assisted by. Yes, when you file,
Within next, follow
Give a-
before the next.
give us a date by which you will file your affidavit, additional affidavit. Give us a date.
Since the other matter is fixed on 19, this can also be fixed on 19.
Shame,
But it
shame.
will be too early whether the petitioner will file an affidavit or not. So that is another reason.
How much time will require to file the additional affidavit? Give
My
a
lord,
date.
1 week, my lord.
1 week.
Okay,
By
list on.
Uh,
Will be
19.
here for some time. Okay, list on 19th.
19th.
In the meanwhile, the petitioner shall file its affidavit. Additional affidavit on or before 14th of May. Serving a copy of the counsel for the respondents.
Obliged, my lord.
May it please your lordships. My lord, in this, I am appearing as a party in person, my lord. Here, my lord,
Just a minute. Tell us whether the court can notify any particular community or any particular tribe.
no, my lord, court
Then
cannot.
why you have filed this prayer? What kind of direction you can issue in this prayer?
My lord, kindly look at my prayer, my lord, that'll be very clear, my lord. Notification, my lord, the original notifications of 1950 stands, my lord. Now the Supreme Court says that once a tribe is notified in the original 1950, of course, except for the parliament, no courts, no tribunals can modify, my lord. We are not before my lord for modifications of that or inclusions, my lord. The interpretations, if my lord will see the original notifications of 1950, it says it's Arunachal and Nefa then. It starts with all tribes, my lord. Now the NCSTs, the Tribal Affairs Ministries, again and again says all tribes would include, even in a local commission in 1964. Also, my lord, there was a meeting, the local commission was, my lord, constituted for the single purpose because there were so many, when 1950 original list came out, the notified came out, many, obviously, my lord, like we have a geographical challenges in the Northeast and so many other places, my lord. Therefore, my lord, local commission was constituted. And when it came to NEFA, my lord, call all the leaders of the NEFA and says that should we specify the names? All were in agreement and no. Let it be all tribes. All tribes would include all indigenous. And this interpretation stands still now, my lord. And on the strength of these notifications and on the strength of these notifications, my lord, we have been issued with a tribe certificates, my lord. Now the problem here is, my lord, these tribe certificates, my lord, has not been honored, my lord. Now, few deprivations, I will say, my lord. There are a student, my lord, who has, my lord, passed in the FTII, my lord. Just few examples, my lord. FTII. Now, he's not getting a scholarship. Why? Because they say that your name is not specifically mentioned. But the interpretation is again and again, it says that all tribes in NEFA would include all of them, all the indigenous.
What is that notification of NEFA?
My lord,
Was a community tribe in the state of Arunachal Pradesh.
my lord, I would like to take right from, can I show the ST original list first, my lord? Then I will show all of them. My lord, kindly come to page 26, my lord, page 26.
Yes.
Page 26, my lord, part 8, Arunachal Pradesh, my lord, as well. My lord has got the list, my lord. Kindly note, my lord, all tribes in the state, including so and so, so and so. Now, my lord, kindly come to local's report at page 32, my lord, page 32. I've just given, it's a voluminous, so I've just given the extract, my lord. My lord has got page 20, page 32. My lord will see, after paragraph 36, paragraph 37, the heading is the tribes of Assam and eastern border states, my lord. Now, my lord will come directly to paragraph 42, my lord. Paragraph 42. May I just read, my lord, paragraph 42? It is clear that in the educational, political, social, and economic fields, many of the tribes in Nagaland, Manipur, and in the most of the hill districts of Assam have attained levels which cannot be reached by other tribes of India for many years to come. Comparison between them is therefore ruled out. At one stage, we thought it would be useful to have the tribes on the eastern borders listed separately. From here is important, my lord. However, we feel that in view of the unique features of these border areas, it will not be advisable at the present stage to embark on such a measure. We held a joint meeting with a representative from Assam, NEFA, Nagaland, and Manipur to examine whether the list pertaining to these states and areas could be mutually coordinated. The representatives of NEFA and Nagaland indicated that specification of individual tribes or sub-tribes would cause difficulties. They urged the adoption of a general description, all indigenous tribes of NEFA and all tribes of Nagaland. So now, and in this report itself, my lord will see at page 95, my lord. The name.
You have this report with you.
I'm sorry, my lord.
Do you have this report, this recommendation?
Whole report you are.
Yes, I have, my lord. I will, if for my lord's assistance, because it's quite bulky, so I have not enclosed. So I
There's
can,
one thing, if you kindly come to page number 33.
my lord.
There is some advice given to the state authorities, para 49, page number 33.
My lord.
There is a direction, in fact, some advice given to the state government to collect the necessary information.
Yes.
What is thereafter? Because thereafter it is not, there is no continuation.
My lord, this, my lord, I'm so sorry, my lord, I could not, I'll provide that, my lord. But let me just, my lord, I will satisfy to, my lord, I will answer to my lord's queries also, later part, my lord.
This is, what is the date of this
Report.
recommendation?
My lord, this is 1964 report, my lord.
1964.
Yes, my lord.
But this remains as it is.
this remains as it is, my lord. And
Any modification of the list subsequent to this recommendation?
my lord, to 2021, my lord.
Where is that?
2021, my lord, amendment, my lord, is page, my lord, will see page 29, my lord, page 29. This is the latest amendment, my lord.
What it says,
My lord, here, my lord,
so far relating to this Arunachal, all tribes including any
all-
modification?
no, all tribes, the word, all tribes has not been, have not been amended, my lord. Of course, but like, for example, any Naga came out and became Nokte, Tangsa, Tutsa, Wangchu, separate tribe. Is
So 30 is the relatable to Arunachal Pradesh.
Yes, yes, my
Entry
lord.
one shall omitted, and
Yes.
one shall be omitted.
Yes.
Okay. So Abor is omitted.
Abor is omitted, then it
Omitted.
became Adia, I believe, my lord, subject to
So,
corrections.
Some inclusions are there, so definition still remains all.
Yes,
including. That's
yes,
what
yes, that's what I'm grateful, my lord.
This particular.
So, my lord, this has been further explained by the National Commission for Scheduled Tribe, my lord. My lord will find this at page 45, my lord, page 45. Agenda number 3, my lord. My lord has got agenda number 3, my lord. May I read the entire thing, my lord? The commission noted that the constitutional orders specifying scheduled tribes in relation to any states are unique in the manner of listing communities and their synonyms and subtribes. The order specifies that all the tribes with a common character as a group and considering the large members avoids a detailed listing and some castes provided a few examples that would fall in the tribe, but not as an exhaustive list. For instance, the list specify any Naga tribes in Arunachal Pradesh, any Kuki tribes, including so-and-so, any Mizo, and any Naga tribes, in Assam state, any Mizo Loshai tribes in Manipur, any Kuki tribes, including in Meghalaya, any Kuki tribes, including in Mizoram, Bhutia, including so-and-so, so-and-so. And my lord will just keep the words now. After Tripura, the words any tribes, including indicates that all the synonyms and subtribes of the specified ST community are eligible to get ST certificates, as the list is not intended to be exhaustive list of all tribes or synonyms. It has been argued that the Supreme Court judgment in the state of Maharashtra versus Milin and others discuss limited issues of certificates only to communities specifically mentioned in the constitutional order, including synonyms or subtribes of a listed community. Therefore, the subtribes or synonyms were alleged to be getting ST certificates, which has become the basis for requesting the separation listing of these communities. The commission observed that the considerations that went into the unique listing for the northeastern states were different from the rest of the country, and therefore the Supreme Court orders have to be read harmoniously with a presidential order and not applied mechanically. Further, the commission was informed that initially when Arunachal Pradesh was part of Assam and known as NEFA, the list of scheduled tribes with effect from NEFA was specified as all tribes of Northeast Frontier Agency, including so-and-so. NEFA upgraded as a union territory in the year 1972 and renamed as Arunachal Pradesh. The Constitution Scheduled Tribes Union Territories Order 1951 was amended, and the same list of scheduled tribes with effect from Arunachal Pradesh was specified as all tribes of the Union Territory, including. This list was not revised with a comprehensive revision order of 1976. The Arunachal Pradesh UT got statehood in 1987. it is reported that people belonging to the Yobin tribe were getting ST certificate as per the interpretation of the words all tribes of the Union Territory, including the communities currently specified in relation to the state of Arunachal Pradesh are listed below. So and so now this is a list, my lord, and paragraph 9, my lord. Given the circumstances of the views of the state government of Arunachal Pradesh that the Yobin community is being disadvantaged by lack of mention of the Yobin community and denial of community certificates, the commission is of the view that the ongoing intention in the presidential order needs to be understood upon scrupulously. If there is any doubt whether the particular community is indigenous tribe of the state, then a proposal needs to be formulated along with ethnographic study. In all other aspects, local inquiries with ethnographic study, if necessary, should suffice to the state to issue community certificate. If the state government continues to have doubts in respect of this indigenous community, they may obtain clarification from the Ministry of Tribal Affairs. No amendment of the presidential order is accordingly required, given its provision, which are also not in conflict with the judgment of the Supreme Court. Here, what it means to say, my lord, because till then we were denied us.
You want to say the suggestion is that
Yes,
if somebody doubts it, sits
Yes.
into an inclusive definition, it
Yes.
includes Yobin.
yes,
If somebody is a doubt or state government creates a doubt that they are not, then a special proposal is to be gone and
Yes.
there required
Yes.
to be a notification.
yes,
When the order still exists, all community,
yes,
including Swen, so it's an inclusive definition,
Yes,
Yobin will be
ex-
included.
exactly, my lord. This is what I meant.
But please tell us page number 46,
Page number 46, my lord.
para 7,
I'm sorry, my lord.
para 7,
Para 7. Oh. Further, the commission was,
last 2 lines.
the Arunachal Pradesh UT got statehood in 87. It is reported that the people belonging to Yobin tribe were getting SC certificate as per the interpretation of the words. Yes, my lord, that's correct.
So that means they are getting the scheduled tribe certificate.
Yes, my lord, it is now the situation is like this, my lord. We have the caste certificate. I'm not denying that this is an undisputed fact. I also, being a Yobin, I have my ST certificate. But what is the use of that ST certificate when this ST certificate is not honored, my lord? One of our students, my lord, recently, my lord, after 70, my lord, this Yobin community, I'll just take a moment to explain, my lord. This Yobin community is consisting of hardly 5,000. And my lord, the place where we stay, the road connection has come just 3 years back, my lord. That today also is a 4x4 jeepable road, my lord. As a student, when I came out from Vijayanagar, my lord, as a young boy, when I could carry only 3 kgs, my lord, I had to walk 7 days, my lord, to get my education. So this is a tribe, my lord. This is a tribe I'm talking about, my lord. So, my lord, we have a certificate.
So thing is that you need a clarification that not, even if it is not included, the
Yes,
certificate issues are valid because it is
Yes.
not relatable to the list only because it
Yes.
is inclusive definition.
exactly, my lord. This has to be
That
honored.
is what you want.
Yes, my lord.
So
So therefore, my lord, the state, in spite of giving us a caste certificate, my lord, is still, my lord, has fell in its constitutional obligation, my lord, to protect the Yobin from social injustice, my lord, social injustice and exploitation, my lord.
Or Mr. P. Yobin. Council appearing, a petitioner in person. Also heard, you are representing 1, 2, 3, 4.
1, 2, and 3.
1, 2, 1, 2, 3. And Mr. M. Katul Learned. Deputy Solicitor DYSGI.
4, 5, and 6.
For the respondent numbers 4 to 6. The Constitution, within bracket scheduled tribes, bracket close order 1950. With regard to Arunachal Pradesh, includes all tribes including, please take your seat. 16th named in it. At 5, at part Roman 18. That relates to Arunachal Pradesh. According to the petition, Yobin tribes of Arunachal Pradesh have their own culture, tradition, customary law, and costumes different from other tribes of the state of Arunachal Pradesh. Though people belonging to Yobin civil tribe community of Arunachal Pradesh are getting ST certificate, a SILTOP certificate, issued by the authority concerned as provided under the law. But people from the said community are not getting the benefits that are provided by the Constitution to civil tribes, are given by the respondents to the civil tribes, civil tribe communities. In its 60th, in its report of 68 meeting, it was 60. The National Commission for Civil Tribes summary record of discussions in file number 1/10/2014 COORD C capital. At paragraph 9 indicated as follows. Page number 46 of my mark quotation. After detailed discussion, after this, para 9 observed as follows. From the reading of the said para 9 of the report dated 25, report dated 25/08/2014. It can be seen that the state government was directed that if it continues to have doubts in respect of the indigenous communities, including the Yobin community, it may obtain clarification from the Ministry of Tribal Affairs, and no amendment of the presidential order is accordingly required to be given in its provisions, which are also not in conflict with the judgment of the Honorable Supreme Court. In the case of Maharashtra, B. Milind and others, as it is, next paragraph. contended by the petitioner in person that people belonging to the Yobin community of the state of Arunachal Pradesh, including the students of the said community, are not getting the benefits being settled tribe as provided under the constitution. Both the state respondents number 1, 2, 3, as well as the Union of India, respondents in the Union of India, 4 to 6, shall clarify its stand by filing the respective affidavits on before 2nd of June, or it will give you some more time, on or before 9th of June, list on 11th of June, but before that you read. In that regard, notice in that regard issued to those respondents number 1 to 6, list on 11th of June.
My lord,
Petitioner shall serve respective copies of this PIL along with the annexes appended to Mr. Such and such and Mr. Such and such on or before 7th of May, obtaining necessary acknowledgement from them in that regard.
my lords, may I take my lord's indulgence little, my lord? There are at least 2 Yobin students, my lord, who have passed in the Arunachal civil service exams, my lord. Now they've been asked to sit in the general category, my lord. My lord, if my lord may, subject to the outcome, my lord, subject to the outcome.
See, question is, since we are taking a general
My lord.
thing of the matter.
My lord,
If anybody is personally agree, they can come, but
My lord.
this appear little
My lord.
possible personality.
You have also not made a UPSC part here.
My lord, I bow down, my lord, to that. Obliged, lordship.
Mr. Carter, but you have not taken steps for the respond number 1. That is the note of 3rd of May. Take steps on the respond number 1.
I'm sorry, my lord. We are under impression that my lord, the copy has been already served to the. In fact, my lord,
Within 2 days, we'll be listing it on.
my lord, during the course of the day, my lord.
Say again, you have to give you another 4 weeks time only after service of notice. Okay.
Or otherwise, my lord, the counsel for the respondent number 1 is also present.
Not appearing for respond number 1.
Yes, he is.
You are appearing for the respond number 1.
Yes, ma'am.
Oh, it's not appearing.
My lord, our
File wakalat. Have you filed wakalat number?
Wakalat.
Yes, madam.
Huh?
Because in IA, the condemnation was already done condemnation.
Conversation done.
There is. They have filed something. Correct. No, condemnation relay control for an.
Where is order of condonation of delay?
It has not been controlled. 29th of April. Yes.
In IA number?
Which I.
Yes, yes, yes. 29.
That's right. Heard Mr. M. Katul on it. UI, Deputy Solicitor. Appearing for the respondent number, appellants. Number 1 to 4. Also heard Mr. P. Taffo. Land counsel appearing for the respondent number 1. Who is your appearing?
I'm for 2 and 4, Your Lordship.
Who is for land management?
I'm Your Lordship.
So do you appear?
Yes, Your Lordship.
2, 3 and 4.
Yes, Your Lordship.
2 to 4.
Notice is about accept position.
And I must P. Pangur and a government advocate on Andhra Pradesh for the respondent numbers 2 to 4. Issue notice. No, it not. It able to adhere somebody in the
Yes, that is a.
Issue notice. As Mr. Such and such for the response accept no formal notice into be issued. Petition assessor have requested extra copy of this memo by appeal along with the annexes appealed there. To Mr. Tafu and Ms. Polo. On or before 07052025. Obtaining necessary activities from the military. Matter has been decided in the apex court or still pending?
It's still pending, madam.
Here is the.
Since the issue involved in this writ appeal is presently pending adjudication before the Honorable Supreme Court in the case of it is not computer.
Original.
State of Arunachal Pradesh versus Mihin Laling. Madam.
Give us in writing.
State of Arunachal Pradesh versus Mihin Laling.
Mihin Lali.
Mihin learning.
Yes,
That's right.
in Mihin Laling case.
So in the judgment itself, I think so it was noted, no?
Yes, 54.
The judgment it is not. State of Arunachal Pradesh. State of Arunachal Pradesh. Versus Mihin Laling, MIHIN. Space bar, LALING. The outcome of this appeal, this writ appeal. No, this appeal will be subject to the outcome of the. Please this matter. After the decision of the Honorable Supreme Court, let's say case of Arunachal Pradesh versus state of Arunachal Pradesh versus Lake. Either of the parties after disposal it SLP before the Honorable Supreme Court make a mention before the court. Yes, right, please.
All right, much.
My lord, in this, my lord, we had filed an interlocutory applications, my lord. The respondents.
This writ appeal by the appellant is against an order dated 070-42025 passed by a single judge in interlocutory application within bracket civil number 146/2024 filed in writ petition in bracket civil number 119/2024 by which the application of the appellant for their impleadment was rejected. Heard Mr. P. Yobin, counsel appearing for the petition. Mr. M. Katul of Net, Deputy SCI, for the respondent numbers 1, 3,
And 5.
5. Will be appearing?
I'm for 4, 6, 7, and 8. 1 into 4 million. 4, 6, 7, and 8. This one is 1 into.
Issue notice. Returnable by Fourth of June. As such and such accepted notice on behalf of such and such, no formal notice may be issued. Petitioner shall serve requisite extra copies to such and such on or before 07/05/2025 of the necessary activity. Petitioner shall take steps to submit notice on the respondent numbers 1 and 2 by registered post reading by such and such, providing the correct and proper addresses of the postal stamps. Will you be able to take dusty service?
Dusty, my lord, my lord.
In addition to the above, the appellant is also allowed to take steps on the respondent number 1 and 2 by dusty only person service, blocking to take any priority. Let's according to on such and such.
Obliged, lordships.
Yes, Mr. Singh, so you have obtained instruction.
I have already communicated in regard to this lordship, but
You have seen no point of keeping this matter.
yes, I have also.
Okay,
But here, lordship, there are certain,
those decisions can you interfere? Just simply we are asking you.
no, your lordship, since it's regard to the policy.
Initially, it
can,
was decided that this will be in this particular place. Thereafter, the government during the COVID period took a decision. Right? And those are administrative decisions. How can you interfere?
Lordship, here, initially, your lordship, this honorable court has passed an order observing, while issuing notice, certain observations were also made that the respondent will also inform the court whether it is possible for state to develop Jamin, which earlier the headquarter was, and now they have shifted to Palin. as a twin city in concept of like Itanagar and Naharlagan, can it be possible to develop or not? In regard to that, some instruction were also sought.
Might have been, but you know the law very well. That order may be there. That is not only that,
Here the
that was up to the
petitioner-
state to develop a particular area or not. See, just for example, Dibrugarh is not far from here.
Oh, sure.
Capital is in Guwahati, earlier it was in Shillong. That was their administrative decision, right? During the Ahom period, Sivsagar was the capital. Now the state wants to develop every part of the Assam now. Dibrugarh has become a mini secretariat. Kokrajhar has become mini secretariat. Decisions of the government. How can you interfere?
Yes, Your Lordship, I am not pressing to the extent of that prayer, Your Lordship.
We leave it to
But-
the state for that extent. It is up to the decision.
And so far as here the petitioners, those who have approached before this honorable court by way of filing this present PIL lordship, they are the major landowner of the aforesaid at Jamin area.
No, just tell us,
Approximately 1,085
Just tell
hectares
us
of
one-
land they have donated, Your Lordship.
Mr. Singh, tell us. A person is very seriously ill. And the family members, they're asking that if anyone is having AB positive blood, please donate. Now the donor who has come willingly will seek anything from that particular person, that since I'm donating you this. What is the meaning of donation? If donation is such, the law is very clear.
On our donated land also,
True.
the
So in
major,
lieu of that, you will not ask anything. Then it's a conditional, and if it is condition is there, it cannot be considered as donation. So-
kindly peruse Lordship, page 109.
Give us a valid reason. Don't bring out all this.
Yes, sir.
Which are legally permitted.
Regarding the factual part, position at
That
this
is the
stage.
reason we are saying that's the administrative decision of the government. How can you interfere? If there is any illegality, show us. Those are different, which you are bringing us, we are placing us before the court.
Was at Jamin Lordship, as per page 110, Your Lordship, they have built major establishment, Your Lordship. Now that has been unused.
Government decision.
The PWD department, police, that is along with the SP residential building.
Mr.
DPO,
Chaudhary, you'll be
these are
remembering,
the,
there are numbers of walking flyovers in Guwahati, particularly the road in the Maligaon area. Now, there was a newly built flyover, walking flyover, right? It was dismantled because there was a flyover subsequent to that. There was a case, but it was, in the initial stages, it was dismissed. Because the court, it was a PIL, because in the public exchequer. The court observed that since the flyover is coming up there, and for the better communication of the people, so we are not interfering and dismissed. Whatever public exchequer, it is a decision of the government. And now you have the new flyover, you have seen that. There, of course, there was not much reasoning, because the case was only because of the public exchequer, and the court did not interfere at all. It was a PIL. That's why I'm saying here, Mr. Singh should know
These are
all the decisions of the government, the policy decision, administrative decision, we cannot. Mr. Chaudhary, what my brother has pointed out, page 44, do you just give him a copy of the appeal? Memo. Page 44. Very,
By amendment, places were changed. So amendment is under challenge. So you are here, that's why my this.
Once my assistant, that is.
Of course,
because
it's a-
the act is under challenge, the amendment provision is under challenge.
So otherwise, as a PIL for shifting descendant will not interfere. We have made him clear on
In
last
fact,
occasion.
there was an order passed on 28th of April 2022 issuing notice to you
In view of this, that is a workable posted on 19th, since I'll be coming.
Okay, okay. But Mr. A.K. Singh, counsel appearing for the petitioners, and Mr. I. Chaudhary. Land advocate from senior advocate. For the state respondents. On the prayer of the council for the parties. List on 19th of June.
19 June.
That's all. We don't say much about it. We'll leave it to you.
Worship, I am for the applicant here in this case. Applicant, I am for the applicant as a legal aid counsel. Worship, recently, I think Amicus Curiae for the victim has been appointed.
You have been appointed.
Yes, for respondent number 2, my lord.
Today,
But
Lordship,
I'm yet to receive a copy, my lord.
and today, if my learned friend, if they don't have objection in regards to confirmation of delay, we can dispose of.
It doesn't have a copy.
All right, all
At
right.
this stage, it is not possible.
Lordship, all right. Can fix the next thing.
Heard. Mr. Dini. Amicus Curiae. For the applicant. Plus applicant. Applicants plus applicant. First to write applicant and applicant. Also heard. I'm a Adele and additional public prosecutor for the state. Pursuant to the order dated 28/04/2025. Ms. Huratanam.
Sorry.
No.
H.
No,
J.
Miss H. Jeram. Hinti Jeram, HINTI. Learned counsel has been appointed as an amicus for the informant respondent number 2. The registry shall serve copy of this application along as the copy of the corrected appeal, criminal appeal, to Ms. Zaram on or before 8th of May, offering necessary acknowledgement from her in that regard. List on 14th May. Register shall reflect the name of, your name has been shown? No.
Yes.
Yes, madam.
Name is there.
Yes, madam.
Yes, Lord.
Okay. Okay. That order is not. So let's start.
All right.
Item number 8.
Wait. My lord, this PI has been filed highlighting, my lord, the absolute lack of progress in the execution of package B of the Itanagar to Banadua highway. If your lords. Peruse is the last order, my lord. Dated 8/4/2025. The state was supposed to file an affidavit indicating, my lord, part wise, I don't know, now he has furnished me something. Report. Despite various orders passed by this honorable court to at least make the road motorable, my lord.
Let's take your seat. Let us go to the report. Let's. Mr. Chaudhary, we seek your help here. So, Mr. Chaudhary, you were there on that day because of the High Court. Ruling. And we have also seen from the road, from the Itanagar side to the new building, the High Court, as well as from UPR to the helipad. Now, let us assume in such a situation that the building has been handed over to us. And then the honorable judges from the apex court or other dignitaries given their consent to participate in that inauguration. They will be requiring the helipad. Now, in that case, from the helipad side also, both ways of expansion, from the Itanagar side as well as from the helipad side. The road is in this condition, you can understand.
I appreciate it. In fact, Manoj, I'm likely to meet the honorable CM maybe today or tomorrow. I will personally take up the issue.
You'll be here for 2-3 days or?
I have to go back tomorrow. There are some meetings fixed.
So you can convey that matter to someone, Mr. Ratan, who can tell us on the next day.
We are already taking up, but in fact, immediately after the meeting, the PWD officers were supposed to have a meeting and push as far as possible.
No, you
And
can
we are
understand,
conscious
you
of it.
can understand this.
I appreciate.
So that is the reason.
We are also equally concerned.
You can inform Mr. Ratan and Ratan can place us or us on Thursday. On 8. Whatever discussion is coming up, they're not passing any order today. So you have.
I will not be here on
I will-
8, somebody will be here. I will not be here on 8, my lord.
Not necessarily, because.
If I may point out a few things, my lord. What has the Lord Advocate General has submitted? I don't know what is exactly happening, but the Chief Minister on the floor of the House said, if this is the progress of the work, it will never be completed. We should actually cancel it. It appears his hands are tied by somewhere. He said it on the floor of the House. Something is wrong. There will be absolutely no progress in spite of your lordship's order also. One person fell into a pit there and died. And there is no way, as your lordship has pointed out, my lord.
Yes, Mr. Dubey, work is not in progress. We have seen.
Plus, earlier it was so, my lord, but we have been, my lord, pursuing the matters, my lords. And my lord, of late, my lord, there has been development, my lord. My lord has seen, my lord, a series of
Development
orders.
of what extent? Why didn't you come personally and see that if you can tell us that there is a development?
My lord, I have been, my lord, I have personally.
Yes,
Still the
Lord, I
same
have
contractor.
yes, my lord. In fact, I may
Lord,
point
I-
out, the contractor that my learned friend Mr. Dubey represents, I don't know what his role is. He gave the construction of the flyover to some other contractor, the road to some other contractor. What is he doing? He is the primary contractor.
Yes,
What is
Mr.
his
Dubey.
role?
What was your understanding on last occasion?
Lord, in fact, my lord,
We
where
want to pass us an order saying that cancel his contract.
my lord, with due respect, my lord, we have been pursuing, my lord, and my lord,
What pursuing? Last occasion you repeated the same thing.
yes, my lord, there has been developments after that, my lord. My lord, if your
No, we
lordship
have not
calls,
seen any development.
Lord, if your lordship calls for the status report as present, my lord, there are differences, my lords. My
Please
lord, I
tell
admit,
us,
my lord, there were.
please tell us from Papun, we can understand that there may be difficulty in completion of a flyover. But what about both side road from Papunala
To Nirjuli.
to Nirjuli?
Yes.
Please tell us by which date you can complete it. Forget about others.
My lord, we have already given a work program to the
Forget,
PW.
forget about
my
all those
lord.
things. Forget
My
about
lord.
all those things. We'll make an observation that if you fail it, they will be at liberty to cancel your contract. And we'll make our observation how you are conducting yourself. And we'll take this matter on daily basis. Day-to-day basis.
Lord, we understand, Lord, that Lord, there has been
No,
lapses.
we are not interested with your understanding. We are not interested. We are interested with the execution of a public law. Do you know how people are traveling? Is it not your responsibility to maintain the road, or is it a
Lord, it is-
concept that
Lord,
whenever
Lord,
the bridge
no,
will
no,
be
no,
over,
Lord,
you will
Lord,
complete
Lord,
the
we
road
we
thereafter?
cannot shy away from our responsibility, Lord. In fact, your Lordship's last order has indicated, and thereafter, Lord, much work has been done on the maintenance part of it, Lord. Lord,
Much work might have been done so far relating to the bridge, but nothing has been done so far relating to the road, both sides of the road. And it is pathetic from this Papunala or
Yes, flyover starts from Papunala, man.
from Papunala to this point.
Bridge point, nothing has been done.
Nothing has been done. So by Thursday, you tell us, and you will have to give report thereafter every 3 days, how you are working on the both sides of the road.
can it be on Friday, my Lord?
No. We may fix it on Wednesday also for your response, then on Thursday from the state's response.
Then let it be on Thursday, Lord. We'll submit our response to your Lordship.
Mr. Dubey, you
Well,
want to come personally and see it here, then you tell us. You are also.
Lord,
a
Lord,
court
I have been
officer.
to, Lord, on 3
doubt,
occasions,
no
I have been
doubt.
personally. Lord.
Mr.
Yes.
Dubey, no doubt you are representing your client, but before that you are a court officer.
Yes,
And,
yes, yes, Lord. I'm, Lord, in fact, by seeing the conditions from my eyes, myself said to my clients, Lord, Lord, this is not the way the things had to be done,
And we
Lord.
will not allow
Lord,
you
we
to
don't take
appear
it as a,
partially. We will not allow you to appear partially. You'll have to come physically by the same road.
Lord, I have
Then you
traveled that road,
realize,
Lord.
see,
And
basically, both myself and brothers are here since
my Lord,
not yesterday, the last Sunday, right? Would have traveled, you know.
Your Lordship has correctly pointed out, if this programs that is fixed on August, I can't believe it, my lord, what will be the impression of this state?
It's honorable.
Because both ways, my lord,
Don't take it as an adversary litigation, Mr.
yes, it is now.
no, Lord, Lord, it cannot be taken as an adversary
Your
litigation, Lord.
conduct we have gathered. Same thing you have repeated on last occasion. Before that also, I myself
No,
was.
Lord,
getting this
with
back.
due respect,
Forget
Lord,
about
there
it.
has been substantial
We'll
progress.
be,
It's not
we'll
that,
be
Lord.
strict on you.
But-
We'll be strict on
Well,
you. Let us see how the state and
We have been-
authority.
We have been pushing from our side as far as possible, but on occasions, your Lordship knows.
We know.
That is why my lord,
And Union of India.
Your Lordship has rightly.
Who is the employer of this contractor?
More.
You are representing Mott?
Yes.
Yes, you have your instruction and ask some officer to be present on Thursday.
Mr.
Communications, my lord.
Mr. Kadu,
In fact, that is where I was about to point out. More than the state,
No,
it is their contract.
Their contract. State is only looking into.
we can
two and
only-
highways.
you are not helpless. That
It is ultimately the Union of India and the ministry, Union Ministry, and the contractor who needs to
It's
be.
not the state exactly, it is because under the not.
No.
We can only try and impress upon them, but ultimately, actual executing agency is them.
And what Mr. Dubey is saying, that since the last occasion, there has been substantial progress. I don't
Nothing,
want to use
nothing.
hard word, nothing, my
Mr.
lord.
Dubey, sorry. We are extremely sorry.
On only 2 pillars, my lord, some iron casting has been done. That is the only thing that has been done. We see it every day, my
You
lord.
are under impression that some new contractor has come and started work.
That is for the flyover, yes.
Flyover.
Yes.
Mr.
But for the present, it is the road that is most important.
Most important.
By Thursday.
And not
And
only
that is why, my
that,
lord.
we can understand that flyover will take some time.
Yes, yes.
Because it's a huge construction.
Yeah.
But it is not that while constructing the flyover, you'll keep the road
Yes.
like that.
Exactly.
It has been pointed out in the last order also, from model village to my lord, Nirjuli, that's a plain area, my lord. 4-laning, cutting, everything is done. I don't know why the black topping is not done. Something was done, totally damaged.
Give us, submit us, no report. You belong to this place, you know what is happening, right? So,
And seeing the physical, my lord, the
we are flying on that road, we know what is happening.
We are not interested in what pillar, what measures. We want visible and actual experience of road.
My lord,
Forget about your 40%, 60%.
my lord sees the market area. This art cutting is being done. The shops are right here. There is no footpath because there is a scope of footpath also in the DPR. Nothing is being constructed. They won't be able to construct also in the present situation. Impossible.
Mr. Dubey,
My lord,
Once again, you are saying sorry, it's not to be on Thursday.
I understand, my lord.
And Mr. Kato, we are saying you are not helping us. If you do not want to exert, we know what orders to be passed.
From what I have gathered from the chief minister's statement in the assembly,
We'll see
it
it on Thursday.
appears it is the central
Mr.
government,
Khattar.
my lord, they are not having this regarding the cancellation of the.
You know what?
Something.
We can only request.
You understand, we understand.
Chief minister made a very
And
honest
Mr. Kato, you
statement.
intimate your client. If necessary, you will have to call them to physically appear there.
And you want something on Thursday?
On Thursday.
Yes.
We're passing on necessary order on Thursday.
I want to hear, my lord, but your lordship has seen what
Be
is.
here on Thursday.
Lord,
Not
I have
from-
one difficulty, Lord, on
Not
the
from-
Oh, you do not
Wednesday.
understand.
We will not hear you.
Lord,
Since the matter
already,
is-
Lord,
You-
I am in
you might
Siliguri
have
on
difficulty.
Wednesday. Lord, I am in Siliguri on
Mr.
Wednesday,
Dubey,
Lord. My
Mr.
lord,
Dubey, the matter.
I
relates to
understand,
public.
Lord.
It is not a personal matter, so a matter
Yes,
relates to
yes.
public. You be here on Thursday. Otherwise, we will not hear you.
My lord, I will be there.
Okay, list on.
Right.
Mr. Chaudhary, whatever, you just convey to Mr. Ratan, Ratan will place it before us.
As I.
We know.
We can only request.
Rightly, right? Mr. Kato will come.
Ultimately, Mr. Kato and Mr. Dubey are to be.
Mr. Kato will come forward with something. Mr. Kato, we have faith on you. Do it. Show it.
Maybe, my lord, executing this contractor, my lord, maybe he can deposit some sort of security, maybe it will spur him
We'll
out.
see to that. If you're not able, we'll ask someone to be here.
Yeah, I will ask.
List on it. Okay. Will not much say anything.
Nothing.
Yes.
Lordship, we will be filing our written complaint, so matter may be taken up after 2 weeks.
Here, my lord, there was just an observation that it desire was expressed that within 6 months we'll do it. But it has, as your lordship knows, this is a very sensitive issue. For today, my lord, the
Take your seats.
I must just indicate to your lordship one thing. For today, Mr. Parme, who is appearing for the other side, he has made a request that he may be accommodated. He has some difficulty. So my young friend may not be put in anything.
The prayer of the counsel for the applicant. Not, sorry.
Lordship, I have responded.
Not Mr. Raichaudhuri, learned Advocate General of the state for the applicant, state. And Mr.
Yes, Your Lordship.
Learned Counsel, a very party numbers. Respondent, sole respondent. On the prayer of such release this matter after 3 weeks on a date to be fixed by the agency.
I will acknowledge.
All right.
Wait, wait. Criminal appeal. Deposition does not reveal anything against the appellant. In fact, suspicion goes to many PWs. There's a post of investigation.
Yes, what do you have to say?
Yes, my lord. On the last occasion also.
For the purpose of, we are not for the final hearings.
For the purpose of bail.
What do you have to say? So you have filed your objection, we have seen.
Yes, your lord.
And what do you have to say?
Your lord, for suspension or for final disposal, my lord? For suspension.
For suspension.
Your lordship, there is a fair chance of succeeding this appeal, your lordship. Fair chance of succeeding is this appeal, your lordship. Because your lordship, as earlier occasion also I pointed out, your lordship, here is a case where prosecution has failed to prove the case beyond reasonable doubt, your lordship. Because your lordship, one court witness is there who has been examined as PW for earlier. If you go through his statement, it's suspicious he may, in fact, in this case. But the person who has last made the deceased person with
Now, what should be the condition if we grant you a bail?
Because you have.
Because he's from outstation,
He's not a neighboring state or.
local jurisdiction.
He was a CRPF personnel, my lord.
That you understand, therefore, suppose we grant him a bail, tomorrow, suppose there is a conviction, how will we bring him to face the sentence? That
That
must
is,
you have to satisfy us.
Yes, but your lordship fits.
You tell us.
You tell us.
My lord, I'm not,
Two things. One,
Yes.
we can say that.
I don't know if he knows any local person or not, but that,
This is one, because that difficulty I have seen.
Yes.
It
It will be difficult because
Local person, they remain in jail
personally,
for
my lord,
months.
Hmm.
This is one. Other aspect of the matter is that if we direct him to appear before a specific police station in a month.
yes.
maybe your lordship before the convicting court, your lordship.
Huh?
Convicting court with the permit.
Or convicting court. Something should be, that is difficult.
And that condition can be given, my lord, this can be heard anytime it is ready, my lord, case is ready, otherwise. My learned friend is also fairly submitting. There is no material, my lord.
Or you say that we'll hear this next week and finalize it.
We'll leave it to your lordship.
Only our concern is as regard the bail. Can you have your instruction from the client?
He's here only.
My lord.
He is here only. We can postpone this date to Thursday, or it will not take much time. You have your instruction, tentatively, just suppose you are granted bail. not sure,
Hmm.
but suppose you are granted bail. We want a very strict condition so that we do not go out of our. Huh?
Otherwise, my lord, this can be disposed of also, my lord. Because all the evidences are not even required to be gone into. Most of them are irrelevant. Otherwise, I will get my instruction by tomorrow, man. I'll ask the local council at
We
both.
hear now?
My lord.
We
We
hear
are
now?
now today.
Yes, I'm ready.
Yes.
Okay, Your Lordship.
How many witnesses?
31.
31 approximately, my lord.
31 from PW.
PW is only one defense witness and one court witness is also a PW one. PW.
Yes, please, yes, proceed. We'll go for the paper book.
Yes, my lord. The second one.
Let us go in a way. What are the saints? That
Yes,
prosecution
I
want
will,
to link.
I will just summarize, my lord.
That's all.
Yes.
See, admittedly, it says circumstantial evidence. Now, what are the circumstances on the basis of which the learned trial court held that the all saints are complete? That is the
There are
issue.
Yes,
basically
that
two
much.
things, my lord. Only two things, my lord. Apparently, my lord, none of the prosecution witness, the prosecution
Where is the
witnesses have
paper?
said
Where is the paper?
that I was in camp, my lord, that I did not go out.
See, basically, section 27 of the Evidence Act, right? Here, there was numbers of telephone calls between the accused and the victim, the deceased.
As well as various other PWs.
No, true. But what happened basically, what they have found, that those things are there, that's how the evidence have come. Now, as per the section 27, as you know, since matter relates to circumstantial evidence, it is the duty of the accused to explain. Here, if you read section 27, of course, now it is BNS, that section 27 of the Evidence Act, that burden hasn't been complied by the accused. You read it, you'll know. And then it was pointed out by the prosecution during the trial, before the accused, but accused failed to explain that. Right? But that is how they want to bring the chain. The prosecution has come to bring the chain on in that manner. Read section 27 of the Evidence Act.
That is regarding the discovery of the stolen property. Your Lordship.
27 is discovery.
Let us see the Evidence Act. Old Act.
My lord, it is on,
That when-
it is on
when-
two
when-
reasons, my lord.
When there is a circumstance
Yes.
which is against, suppose last seen together. It is established that it is he is living last seen together. Now he'll have to make an explanation that no, though I was last seen together, but during this period such and such happened.
Yes, everything.
That was
is
the
there.
case in, I think you
Yes,
approved
yes,
that case.
yes.
That somebody both
Yes.
two friends
Yes,
drinking
yes.
together. What
My
is this case?
My lord, here last theory will not
by
come
bump.
in this case.
No, not this,
no,
but
no,
that
by
that we have dealt with.
Yes.
I authored.
My lord,
that. What is the judgment?
By bump.
By one.
Do you have a number of any copy of the judgment?
I can bring it right now. I don't have.
Give that to me. Who are the star witnesses according to you?
My lord,
Prosecution star witnesses. On the,
prosecution.
see in term, no, there is no star witness, I understand. But
No.
as per the judgment,
Yes.
who are the star witnesses? On the basis of who?
Basically, two things, my lord. That I came back for a flight from Delhi to Guwahati, my lord. There was another person, my lord, some Das, my lord. His purse was found near the this is person's body in the same field. That is the only thing. But this Das, my lord, he said, I have never seen him. He in fact says, I took out my purse. That is while I was taking out the trolley after lending, my lord. He took out some money. Usually he keeps it in the front pocket. He took out some money, kept it in the front pocket of his shirt, then kept the purse in the back pocket. He also says, I did not recall seeing him. That is only
so
your
such case
presumption.
is that it was established that that bags belongs to that Das.
Yes,
Isn't it?
yes.
And
But it was
that
not
bag,
established that.
that bag is found with the near the dead body.
Yes,
And therefore, the presumption, it's not a saying.
yes, yes.
Presumption is that
Drawn
since
against.
bag is,
The money.
you have traveled with the
Yes,
person
yes.
to whom its bag belongs, therefore you must have
Might,
something with this,
yes.
the relation to that.
Yes.
But this is a presumption,
There's
this
a
is not a chain.
Yes, that is what I'm saying,
That-
madam.
that is the-
There is only two things. And another one is, I made a statement myself
160.
that she came with PW4. She drove it. Apparently, this accused was, or deceased was a sex worker. It is in my statement itself that during the daytime, I had on 2 occasions. And there were other persons, so many persons, my lord. In fact, Ismail first pointed out, all suspicion points to PW4 actually. So on the other reason is, how can the accused person, I myself said, when she came with the PW4 in the evening, at night time around 9:30, I could smell that she was drunk. I could smell the alcohol on her. That is the reason. If I was not near, how I could have smelled the alcohol. That is the only reason. I clearly said, I talked to her through the gate. I could not come out. And all CRPF personnel have said that the walls, there was no damage to the walls. Nobody has gone out. There's no, in fact, star witness, my lord, as your lordship was pointing out. There's nobody, my lord, in fact, remotely connecting me. I have got the judgment, I'll have it printed out.
Just a minute. Yes, please come. Start. Yes. Just point out any on whom.
I have noted it down that according to that PW4.
Yes. You also the court witness also.
Court witness, PW4.
Suspicion, my lord,
Why you want to say that chain is not complete?
there is nothing in the evidence. I can read all of it, my lord. There is, no, forget about due great respect, my lord, completion of chain is, there is no chain, my lord. And my lord, how can one set of prosecution witness be totally discarded, my lord? That is also against what the Supreme Court has said. And nobody has implicated me, my lord. Nobody. And one more thing, my lord. that field, my lord, where the deceased person's body was found, your lordship will kindly know.
Just a minute, huh?
Where is the IO's evidence? Kindly read.
If I may point out before reading IO's evidence also, the Mila. Deceased person's, my lord, body was found near a field across the CRPF camp. The first police officer who went to the PO categorical that there is no sign of any resistance. And it appears that the body was brought there and hidden. The bush were placed above. Doctor is categorical that she died because of strangulation. IO says no sign of struggle. OC says no sign of struggle.
What the postmortem says?
Postmortem is strangulation. Exis the doctor term, my lord. I find it hard to pronounce, my lord. And that is clear.
Please, before that, tell us who are those witnesses on which the learned Sessions places reliance?
My lord, the learned is very difficult, my lord. Learned Sessions has quoted everybody, my lord. Total presumption, my lord. How can a criminal trial be, my lord, somebody be convicted like this? My lord, we write in our appeal that appellant was convicted on conjecture and presumption. This is a direct case on that, my lord. We write that on format, but this is what it is. If your lordship asks me a pointed question that which is the witness, my lord, I can't point out, my lord.
Who is the IO? IO PW?
IO is, my lord,
PW 27.
PW 27.
Huh?
PW 27.
215. Page number.
215. I can read this, my lord. This will cover. The last person, PW4, who brought the deceased by vehicle, his conduct is very suspicious. He goes off, my lord, to
215.
various other places.
215, no?
Yes. Yeah, I thought.
OC.
No. Oh. On 19/10/2021, I was posted at Walukpong PSS officer in charge. On that day, at around 1000 hours, one inquiry report is received from ASI Sangnabu of Walukpong PS. It is reported that the telephonic information was received regarding recovery of a female dead body lying at the backside of Walukpong General Ground. As earlier directed by me, he conducted inquiry regarding the recovery of dead body and found female. A found female dead body in semi-such and such condition, such and such. Was pulled down, sling of vanity leather bag was around the neck and tongue was protruding. The dead body was inside the bush lying on her back, which seems to be covered manually to hide. On receipt of inquiry report, I have registered Walukpong case number such and such and under today investigation. During investigation, I have
Gameshwar Das was examined as?
my lord.
Gameshwar Das was examined as?
Was examined as
PW 23, page number
23.
206. Page number 206.
206.
Please read, please.
Yes, yes. During investigation, I have conducted inquest over the dead body in presence of witness. In presence of executing magistrate Walukpong, the dead body was identified as late such and such. During inquest, it was found that the sling of the vanity that was tightly wrapped around the neck of the deceased. I have forwarded the dead body to CSC Walukpong PME. After PME, the deceased was handed over relatives such and such. During observation and search of PO, some items like pair of black shoes are nicely kept with a safety grid wall of pavilion and single piece of earring, a brown leather purse containing Aadhaar card, PAN card, RC 2 numbers, driving license, debit card, all in the name of Sri Gameshwar Das. Sri Hemakanta Das was recovered, was recovered from the PO. From the relatives of deceased, the phone of deceased was collected and requisition of procedure was met. The owner of the purse was also located and called to the PS. On being examined, such and such disclosed that he has lost his purse in Indigo flight number while coming from Delhi to Guwahati. In the course of investigation, CDR received an analysis. It was found that there were 6 incoming calls and 4 outgoing calls from phone number such and such which belongs to Muhammad Iqbal. All the said calls were made within a span of about 1 hour, that is from 21-24 hours to 23-24 hours. Accordingly, Muhammad Iqbal was summoned and appeared at BS Balukpong. On interrogation, he confessed that he was in constant touch with deceased. As per Muhammad Iqbal, the deceased was a Sasensas who made at hotel near Durga Mandir, namely Sasensas. Even on 1710, at afternoon, he had Sasensas with deceased such. He also confessed that he called the deceased to come to Upper Balukpong General Ground, which is near to his camp. He also informed Birender Negi, Constable GD, that late Sasensas is coming to meet him. Birender Singh Negi, he was also examined. He stated both the accused and he noticed the guard alighting from a car while they were hiding in the backside of barrack. During further investigation from the mobile phone, Muhammad Iqbal, 2 flight tickets of Indigo Airlines, Jammu to Delhi and another Delhi to Guwahati, dated Sasensas are found. It is the same flight in which Sri Gameswar Das was traveling and lost his purse. Gameswar Das was in seat number Sasensas and Muhammad Iqbal was in seat number Sasensas. During examination, Muhammad Iqbal stated that before me that on the date of deceased, the deceased has not come near to him, he has just seen the deceased through the fencing. The confession statement of Muhammad Iqbal was recorded in a case relating to Immoral Trafficking Act. The copy of statement Sasensas in this case. In the statement, oath has confessed that deceased came near to him and she was smelling alcohol. It is said that the money purse that was missing 1 month back, that is on 16/9/2021, was recovered from the PO.
When as per postmortem report, when as per the IO, when body was recovered?
That is 17th, 18th. 18th, yes. 1810.
10 year
2021.
2021. At
Yes.
what time?
Just a moment. From the ASI's report.
No, it is in the FIR also.
Yes, there's an FIR. Just a moment.
16 hours, afternoon, 4 o'clock.
4 o'clock.
Around 4. 1600 hours.
Was in FIR.
The copy of statement has confessed that deceased came near to him. It is said that the money purse was missing 1 month back, i.e. from or recovered from PO is a playground where everyday boys used to play football. No one noticed or found the purse before the incident. Further, the PO where the purse was recovered is far away from BCT Road, and there is no any link near any place for suspecting any other person for bringing the purse to PO, except accused Muhammad Iqbal, who is stayed at barrack adjacent to ground. The LS accused has planted the evidence that is money purse to mislead the investigation. In the course of investigation, biological samples of victims' Sasensas was sent for FSL for examination. The FSL is yet to be received. The deceased mobile phone could not be recovered till then. The mobile phone moment was seized and found that call logs WhatsApp chats were deleted. Hence, the mobile was sent for SFL examination and retrieval of deleted data. Report is still awaited. The PMA report is received. The doctor opined that the cause of death is due to asphyxia because of strangulation, ligature mark found around the neck and contusion on both labias. On completion, Sasensas. These are the annual roadship may kindly have the cross at page 219. It is a fact that the accused person has not confessed that he has killed the deceased. It is a fact that Gameswar Das has not filed any missing report of his purse. It is a fact that there is no sign of struggle at the place of recovery of body. It may be possible that the dead body is dumped after killing somewhere else. We have not found any footprint at PO. We have not used hand gloves. These are very relevant. This is the only thing. I have exhibited the duty register of CRPF camp. There is no entry and exit mark of the accused on the duty register. It is not a fact that some other person might have planned the materials near a dead body for incriminating the accused. It is a fact that I could not retrieve the WhatsApp chat from the mobile of the accused. The same is still at FSL. Last call from the mobile of deceased was made to Santosh Chetri. This is the PW4 and the court witness. During the night, mobile location of Santosh Chetri was found in Lower Balukpong and mobile location of deceased was found in Upper Balukpong where dead body was found. It is not a fact that the state of Santosh Chetri kept changing. I do not know if Raja Narjari went to the funeral and he was present in Balukpong. It is a fact that Birender Negi, an accused, has seen the deceased through the fencing and thereafter they went inside the barrack at about 8 p.m. But from the CDR, it is reflected that the accused has contacted the deceased at about 10 p.m. I cannot say Raja Narjari has called the deceased from the phone of Santosh Chetri, but it is a fact that the last call of the phone of deceased was made from the mobile of Santosh Chetri. And during that time, the tower location of his phone was Lower Valukpong and tower location of deceased phone was at Upper Valukpong. The distance between Upper and Lower Valukpong is about 5 kilometers. As per the PME, death was caused before 36 hours of examination and calculation is found that the death was caused between 10 p.m. to 3 a.m. during night. It is not a fact that I filed the charge sheet against only on suspicion. I filed the charge sheet against the accused on the basis of circumstantial evidence which shows that the accused was in constant touch to the deceased on the night of her death. The deceased was dropped by Santosh Chetri with a red colored car at the PO, which is situated near the CRPF camp where Mohammed Iqbal used to stay. One Puja Tamang has seen the deceased alone at the PO after dropping by car. As per CCTV footage, the car returned in a few minutes after dropping the accused. On analysis of CDR, it was found that the last location of phone of deceased and accused were found together. The accused kept changing his version once he told that he has not met the deceased on the night and seen her from fencing later on. In another case, he disclosed the deceased was smelling alcohol. The recovery of parts of Gameswar Das, another striking evidence. Gameswar Das and accused traveling from Delhi to Guwahati on same flight, and during that time, parts of Gameswar Das was lost. Same parts was recovered near the dead body of deceased who came to meet the accused person before her death. Entire materials available on record points towards Mohammed Iqbal and none other than he has committed the murder. I could not find the motive regarding murder of deceased. It is a fact that this was constant on his phone with other persons. I have mentioned the CS already. It is not a fact that dead body was recovered near CRPF camp and accused inside the CRPF camp, and as such, I filed the CS on suspicion. I have collected CDR of phone number of deceased for 10 days. We could not collect fingerprint from the letter. It is not a fair evidence document does not justify the CS filed by me. No biological materials were collected from PO except the body.
I think this is I have Arrears, also.
My lord, the judgment that the Roshi was referring to.
This is that by bump.
Yes.
You finish it off?
This is like this. That's it. It is a fact that on the night call with Rahul Chetri was 17 times and with the accused person 10 times. It is a fact that I have not mentioned in CS that collection of fingerprint is not possible. There were calls from various other persons, my lord, various PWs.
Hard shaving. Okay. Anything you want to rely some judgments, anything?
On contradictory statement, because the,
You can rely.
I will-
You said.
I'll just give.
Want to say anything?
But all judgment is against me only. Against you.
Give us those judgments against you. I will not quote your. quote you.
My only one judgment on the law point that the 161 statement which has been given in the former case
Case,
that has been relied upon and that is usable, no doubt. But that is not even sufficient to give conviction in this case.
Exactly,
Yes.
exactly.
I will only
That's the way
rely
I-
the judge. Give that.
Again, corroborated statements have to be there.
Exactly,
That
my
you
lord.
cannot pick up.
Yeah,
The
from-
management has been very fair, man.
And my lord, your lordship, in this case, the court ought to have wait for the FSL report, my lord. FSL was never received in this case.
Their
Many things would have
swear
come,
and
DNA
everything was
report,
taken, but
FSL of that WhatsApp
Yes.
messages and other.
Yes,
Yes.
nothing is there.
Okay.
Well, I'm relying only one judgment, your lordship, one judgment.
Give this file to me.
But as for the last order, I was directed to seek instruction, what happened to the NGT order, my lord. In fact, I have come to know that from the NGT has disposed. Allowing the application and directing this stone crusher to shut down. The order is basically, I've gone through it. It's basically because of the NOC issued by the DFO. Which required that
No. Issues are same here in both the cases.
No, my lord, this is with respect to one of the, this, stone crusher.
None appears for issue. We'll keep this.
Yes, my lord. And moreover, the other parties.
That's another thing. So now we got the. None appeared for the petitioners on call. Do names of ten councils have been reflected in the call list. Mr. Ratan Lalit, Additional Senior Government Advocate, Arunachal Pradesh. Placed a copy of the order dated. Now you are here, Mr. Ma.
May I please? Yeah, Lordship. Well, in this matter, my lord, last order,
That has come.
yes,
Have you gone through?
yes, I have gone through, yes. So it's a similar matter, same facts. We also challenge the order passed by the ADC. And NGT also passed on the basis of that order passed by the ADC, which is says that 5 kilometer, within the 5 kilometer, both are the RKC and Balaji, both the stone crushers.
But here with respect to.
Now, what is to be done today?
My lord, well, I pray that being a similar matter can be disposed
Dispose of in terms of what?
Maybe in terms of this NGT, which is,
Until and unless he says the same.
My lord, here,
I can point out the facts of the
So
RKC.
therefore, we'll have to pass
Yes,
an independent. assessment.
I'll just take two, three documents, Your Lordship. One important is, I'll just go to
Mr.
Page-
Page, from how will you show the location of the respondent, private respondent is similar to that of the?
yes,
the affidavit?
yes, I will show from the documents, Your Lordship.
my lord, in fact, Mr.
Ma-
Martin,
Until and unless they say.
Bolo, Mr. Martin.
I'm for Balaji Minans, respondent number 9 in PIL. For
So
delinquent-
Balaji, to the judgment is
Yes.
already passed.
Yes.
There is another private respondent, another.
So far relating to Balaji, NGT has passed an order.
Order, yes.
Now it remains RKG or something like that.
Yes.
RKC is remain, RKC,
RKC.
yes.
So you are for?
I'm for Balaji.
Who is for RKC?
Mr. Tony Martin, he was appearing.
Mr. Roton.
Yes.
It is now the state is to clarify whether this judgment will cover the case of Balaji also.
Yes.
That's all.
RKC,
RKC also.
yes.
Balaji's case, because it is same kind of. an
same
order.
facts.
Same order.
Same
Order is different.
Order is
order is
different.
different,
Order is different.
yes.
But you say that the same set of facts. Now state is to clarify whether it is same facts or not, or Balaji is to, RKC is to clarify whether it is Balaji. State we cannot pass an order.
Yes,
So that much we can record today and ask them to file affidavit on this point.
Yes, ma'am.
Mr. Ratan, see, basically it's very clear. Now, for the respondent number 9, NGT has passed that order.
Yes.
You has found that inside the reserve forest. Now, if the locations are similar, because the
RKC
location.
is, my lord, the location is different.
No, you
That
have to
only
make a
you-
statement that
that
this
You
is
have
not
to clarify.
Yes.
We
We
will
cannot,
not, we cannot say that.
Yes,
Then you will have a chance to respond to you.
yes.
Or I can show from the report.
No,
Yes, okay, it's okay.
Suppose
You
even
have
if
claimed-
you are,
that
even
is,
if
you
you
have
are
asked-
convinced, we will have to ask him.
Yes, yes.
Whether this is correct or not.
Right, obliged.
Card Mr. Asma, counsel appearing for the petitioner. Petitioners. Mr. Anderson. All right, that is Lassina Government Advocate on that service. You are appearing for whom? Mr. Ratan, up to response numbers 1 to 8.
1 to 8, my lord.
Okay.
1 to
7.
8, my lord.
8, Chairman.
Except for 3.
Who is for 3?
3 is
Member Secretary.
3 is
pollution control
Pollution
board.
control.
pollution control board.
Any standing counsel?
My lord, in fact, they appoint per case months in.
Anybody is appointed here?
I think
Name for?
Pangu is appearing in that matter.
No, because somebody was justice service was made, but I don't. Steps closer to the. Problem with the early.
In terms of available.
Okay. In terms of the order, our earlier order. That is 08042025. Mr. Ratan Lanet, additional cinema has placed the copy of the order dated 20-01-2024, passed by the National Green Tribunal, Eastern Zone Bench, Kolkata, in OA number 10/2024/EZ, relating to respond number 9, by which the said tribunal found the respond number 9 within 500 meters of Mebo Reserve Forest. Under, it's under Pasighat district, right? Eastern district. Registry, sorry, the state respondents by an additional affidavit shall clarify the location of the stone crusher of the respondent number 10, whether the same is within the reserve forest area of which village, which forest? No. Within the area of Mebo forest, inside the Mebo forest or not, by giving its locations.
My lord, I believe the objection as per this respondent number 10, RKC, is not they are located in a distance not far from the reserve forest, but it is they are located near a stream.
Which is within the reserve forest or not? Within the stream, that's what we mean.
It should be 5 kilometers away from the reserve area.
5
kilometers.
Whether the location of
If
respond
they-
number, the stone crusher respond number 10 is
500
kilometers, not 500 meters or 5
5 kilometers away from the reserve.
kilometers away from the
From the
Mebo Reserve Forest.
Mebo
district or
Reserve.
not,
That
giving its locations.
obviously.
Obliged.
List on when, Mr. Ratan,
My lord, let it be after 3 weeks now.
give us a date.
Yes.
Let me give. 9th June,
Too
my lord.
far, too far. Today is 5th only,
Yes, my lord. 2, 3.
4th of June.
4th of June.
Obliged.
But regarding respond number 5, justice service was done, nobody appeared.
Respondent number 3, pollution.
You can inform. The records is there.
My lordship. Lordship, I beg to mention item number 15.
1-5,
Yes.
yes.
I'm referring for the respondent number 66. And this living council is out of station on medical ground at Nepal.
Who is appearing for the petitioner? Who is appearing for the petitioner?
Yes, my lordship.
2016 matter, what's your point?
Yes,
What is the issue about?
on medical ground.
What is the issue?
Yes, the living council out of station on medical ground.
What is the issue involved in this writ petition?
It's about land dispute. About land dispute.
On the prayer of the council for the parties,
My lordship,
when do you want?
a matter may be fixed on 9th of May.
Today is also fixed. If I'm
Yes.
fixing it, there is hardly is involving anything. See, petition is only of
7/16.
along with the order is of 63 or 69 pages. Right?
Yes.
The order series is of 45 pages. How much time you have been taken? Every date. Even in last occasion. Tell us a date. Give us a date, not by only your side, jointly.
Consent, yes, consent is
We have
on
taken consent on 9th.
9th of May,
9,
of May,
This month.
not on 9th of May.
not in 21st of this May.
Yes, either on 25th.
As agreed by the council for the parties. List on 21st May for hearing by both the parties. That is to be noted herein. That after verifying all the relevant records, including the records of the Directorate of Land Management, Government of Arunachal Pradesh, and hearing both the petitioner and the respondent number 6. The impugn order dated 12/04/2016 was passed by the Deputy Commissioner from District Magistrate Idanagar Capital Complex, upholding the allotment of the respondent number 6. Allowing her to continue the construction over the land involved in the case that was allotted to her duly as per the said authority, which has been stayed by this court on 06/09/2016, while issuing notice to the respondents. And the interim order dated 06/09/2016 is in force till date. The interim order dated such and such past earlier shall remain in force until further order of the court. Yes, next.
Much obliged.
May I please, I beg to mention item number 11. My lord, this matter has already been transferred to principal bench in earlier order copies here. Same matter has been taken up in principal bench. Page number 6. Serial number 16 is there. Same matter is pending in principal bench. So till the outcome of the principal bench.
কোথায় দিয়ে নেয়নি কি এটা? কোথায় দিয়ে বলেছি?
A respondent has filed their affidavit today. I got the affidavit. We'll file a rejoinder and wait for the outcome of the principal bench.
By an order dated 04042025, a coordinate bench of this court transferred this writ petition to the principal seat of the Guwahati High Court at Guwahati for placing the matter before the Honorable Chief Justice in his lordship's administrative side, so as to take up this petition along with WPC number 48612024 and WPC number 19/2025, where the issues involved in this writ petition are similar to those two writ petitions.
My lord, entry may be
So that-
continue.
So as to avoid the conflicting opinion. In view of the above, the either of the parties, no, individual, registry shall list this matter after disposal or be connected to the petitions pending before the principal seat of the Guwahati High Court, WPC number 4861/2024 and WPC number 19/2025. Pending before the court of law. Pending before the principal seat of the Guwahati High Court at Guwahati. On the basis of a mention and by either of the parties.
Much obliged.
Take back your disorder.
My lord, I beg to mention item number 16 for withdrawal, Your Lordship.
You want to withdraw?
Yes, Your Lordship. The petitioner is no longer desirous in pursuing the
What's
matter.
your good name?
D. Tamuk, Your Lordship.
Also appearing for the petitioner. File to lay. On instruction. Praise for withdrawal of this petition. To which counted for the respondents. Have no objection. Accordingly, petition stands dismissed on withdrawal. Okay.
I will respond on 1 to 4. And 1 to 4. Obliged.
Mr. Preacher, that's one number 1.
My lord, I beg to mention item number 17, my lord.
Yes, what's your prayer?
My lord, leading counsel, due to a personal problem, is out of his station. Therefore, matter may be adjourned forward.
Fine.
Order, my lord, government is supposed to file their affidavit in case.
And declare the council for the parties, place this matter after 4 weeks on a date to be fixed. So this too.
My lord.
Okay.
My lord, I'd like to mention item number 5. My lord, I'm for respondent number 3, Pasighat Smart City Development Corporation. My lord, we were required to file one status report as regards to the progress of the work. My lord, I have received the detailed progress report today. My lord, if the matter can be fixed on the 9th of June, we will file the report prior to that, serving my friend a copy of the same, and matter can be taken up for final hearing.
You are appearing for?
Respondent number 3, my lord. Pasighat Smart City Development Corporation.
You want to file status report?
My lord, on status report, and then it can be taken up for final hearing. My lord, if it can be fixed on
Before that, we have to issue rule. Stage and no stage. Rule has not yet been issued.
No, my lord. My lord, it's a covered case actually. The like matter was already decided earlier. The writ petition was in fact dismissed.
You are Mr.
N. Khera, my lord.
Okay. Council appearing for the respondent number 3. Submits that. The respondent number 3 shall file an updated status report, to which the counsel for the petitioner has no objection. Next letter. Notice in this case was issued on 07/02/2023. The respondents have already filed their respective affidavits, and the petitioner is yet to file the rejoinder to the affidavit of the respondent number 3. Issue rule. As parties to the proceedings have already entered appearance and filed their written affidavits, no formal notice may need to be issued to those respondents. Place this matter for hearing on 28th of May.
My lord, fine, my lord, 9th of June, my lord.
Not on 9th.
My lord, can we suggest a date earlier than 28th of May? These are preoccupied.
20 is possible if you want. 28th of May. In the meanwhile, the respondent number 3 may file its updated status report. Next, further, the petitioner may file its Rejoinder to the affidavit respondent number 3, if any, on or before 14th of May.
Madam, 19th of May will be possible.
You want 19th May, Monday? Okay, 19th May.
Highly objective.
Deeply ordered.
Lordship, I would like to mention item number 7. I'm appearing on behalf of L. Perme, Standing Counsel for Power Department. Matter may be taken up after 1 week, Lordship. Lordship, next week, Lordship, there is an instruction, Lordships, this is pension matter, Lordship. Next week, Lordship.
Are you getting the provisional pension?
Lordship, provision pensions already issued, Lordship. Provisions was already provisions, Lordship. Still, Lordship, provisional PPO is issued, but the monthly pension is still not given to the petitioner, Lordship. In this connection, Lordship, there is a notice issued to the petitioners to approach the Treasury office to complete the process, Lordship, for sign of the some documents, Lordship. Which is also, Lordship, I consult with my own instruction, Lordship, consult the, he told me, my petitioner Lordship told me that he already completed the process of Treasury office. There is notice issued by
Okay, on the prayer of the council for the parties, list on 14th of May. That will do. Yes, 14th May. Any other mention? Okay, we'll come back at 2. Yes.
My lord, I want to mention item number 10.
Yes.
Item number 10, I am a petitioner. I have taken consent of the other parties. The leading counsel is unable to attend due to personal difficulties, my lord. Item number 10.
Well, I am appearing for the respondent.
Yes, when do you want?
After 2 weeks.
Yes, any objection?
My lord, can there be a date, my lord, fixed date so that, my lord?
Even today, this matter is fixed, Mr. Sekho, that you have seen.
Lordship, my lord, but because unfortunately the counsel for the petitioner is not present. If not inconvenient, my lord, on 28th of May, my lord.
28. It will be end of the month, end of the May in that case. Okay, on the prayer of the council for the parties, list on 2005 2028. Right.
Always.
May I, my lord? My lord, item number 17 was mentioned by the petitioner. My lord, we were not informed that it was being mentioned, but I have spoken to them, my lord, if this can come up on a fixed date of 9th of June. Since we are-
Already we have mentioned it for 4 weeks. After 4 weeks.
My lord.
So we are not giving any date. So difficulties we are fixing the matters on the fix that the councils are taking times. And what we have seen from the orders is Earlier also it was assumed the prayer of the council for the petitioner. So we are not giving the dates. It will be up to the registrar to give in a particular. There are local councils, no issues.
My lord, we are for respondent number 2, the actual answering respondent in this matter. We are from outstation, my lord. The respondent number 1 and 3 are state. And also, my
Someone
lord,
mentioned on behalf of Mr. Mukherjee.
that is petitioner.
That's true. Anyway, I will give a date. We don't know, they might have signed in the meantime. So it's mentioned in the first half itself, right?
My lord, we were not intimated.
We'll give a date. It will come out in the order. Okay. I'll give it.
Highlight.
My lord, just made an order dated 14 May 2024, passed in WPC 97/2021, has not been complied with. So, my lord, I have my lord, said order has in said order, my lord, petitioner has sought the directions from this honorable court for the payment of past possession of the land which was occupied by the army since 1986 to 2009. And 2009, a past notification has been issued by the state government, and that notification has not been completed, and it was completed in the 2020. So interest has been also sought as an statutory benefit, and it has also been directed, my lord, directed to the deputy commissioner to examine the matter and consider the matter within 3 months. Till that order has not been complied with. So this is a notice may be issued, my lord.
Where is Kato? Where is Mato Kato? Ask him, is here. Is required. Mr. Kato, please come in.
6 and 7. 6 and 7.
Land acquisition, নতুন content. Another copy to him. Second copy tonight. Okay, you have the copy?
Yes.
Good. Second copy petition আছে জানো? আছে। Mention আছে। Right. Yes. Give him your copy.
I provided.
Mr. Kato, just see one thing. In fact, this is a matter relating to the Defense Department have taken over land of the petitioners. Now you can come to page number 26.
Yes, ma'am.
Read from the third line.
It is contended that
No, while contempt case was pending. Page number 26.
ma'am.
Got it?
Yes, ma'am. Para 6.
Para 5, that is continuation.
Okay.
So
The respondent, again, the respondent authorities had failed to comply with the
then you read the third line, while contempt case.
while the contempt case number 39 AP 2018 was pending before this court, the government of Arunachal Pradesh has issued notification by memo number so and so dated 3rd June 2018, and land compensation award acquisition award was made by number so and so dated so and so by invoking urgency clause section 40 of so and so madam 2013, and payment was made to the petitioner, but it was found that the petitioners were paid only to the value of the said measuring around 108.8 acres of land, including only 1 year of interest without including statutory benefits of interest from the date of possessions of the said land or notification. The petitioner received remaining 20% of the compensations of the land in the month of March 2020. And the 80% of the compensation amount was already paid in the year 2019 prior to the release of the 20% in terms of section number 40 of this Act 2013. It is contended that since the responding authorities had failed to provide these three benefits of interest for first possessions of the said land, the petitioner submitted representations on so and so date to the additional deputy commissioner, and the defense estate officer, the Itanagar, by stating that the petitioners have accepted the amount of land compensation, albeit with protest against non-payment of the interest accrued. Defense estate officer Itanagar, by number so and so dated so and so, has rejected the said representation.
Now please come to page number 46.
46, madam.
Read para 45.
Paragraph 45. In view of the discussions made herein above, this court is of the personal opinion that the petitioner are not entitled for the relief sought for in terms of the provisions of the section 30, 80 and section 93 of the Act 2013. Thus, this court is not inclined to grant the same under the aforesaid provisions. However, in view of the principles of the laid down by the law laid down by the Honorable Supreme Court, this court direct the Deputy Commissioner oblique the collectors to examine and consider the questions of the payments of the rent oblique damages to the petitioners from the period when their respective lands were taken possession, that is 1986, till the date of issuance of the notifications in the year 2009, and the interest from the first notifications in 2009 till the award on the additional compensations only for the reason that the petitioners have been already provided interest for 1 year. Such exercise shall be completed within a period, within a 3 months period, 3 months from the date of the receipt of the copy of this order.
Now, please come to page number 19.
My lord, Annexure 1.
What is the WPC number? First page itself, 19 itself, page number 19. What is the WPC number?
WPC number, my lord, 97 of 2021.
Good.
Filed by the.
Right, that doesn't matter. Now, you have already read at page 26, the para 5, that the award was made on 26th of November 2019. Award was passed.
Yes.
Urgency clause was erased. 80% of compensation was paid. And then interest was paid for 1 year that you have read. And then subsequent to that, the remaining 20% was also paid to them. Right?
Yes.
They are aggrieved. If they are aggrieved with such an award, what was the duty of the person interested under a 2013 Act?
Malad, if such provision, then Malad, section 63, Malad.
Now, 64,
64,
reference was required to be made.
Yes,
Now,
reference.
instead of making a reference, because time was already elapsed, they preferred a writ petition and obtained certain orders. What is your view that is there will be contempt will be applicable?
Well,
rightly, wrongly, an order
Yes,
has
ma'am.
been passed in a
Yes,
writ
ma'am.
petition where the person interested were required to
Yes, ma'am.
go for a reference.
Malad, my respectful.
But they have not referred. After the lapse of time,
Correct.
they have approached this court in by a writ petition.
Malad,
Whether those writ petition has been adjudicated.
Malad.
What is the law of the Supreme Court? Whether such kind of writ petition or any direction can be considered to be executed. Whether this order is executable. See, we can straight away issue notice.
Malad.
But why I am saying it, because there are specific directions of the Honorable Supreme Court. There are a judgment, not only a single judgment, there are judgments passed by 3 bench judgment, which you normally call full bench judgment, right? In this regard, it is very categorical. Here, the court found that award was made 26th of November 2019.
Correct, ma'am.
And you have seen that the petition was filed in 2021.
Yes, ma'am.
And then in 2020, they have received the remaining 20% also. But they did not prefer any reference petition. Anything aggrieved by an award passed by the collector, you are supposed to prefer a reference because this is a special act.
Yes,
You cannot go beyond this act.
Correct, ma'am.
Land was acquired under this act.
Well,
Whether any direction is being issued by the in a writ petition, though nobody had executed or some order has been passed. Now at this stage, whether this order is executable or not.
My limited understanding is, since there is a special provision under the statute and law laid out by the parliament, wherein the appropriate the steps has to be taken.
Now they have, that is the reason
Yes,
they
ma'am.
have not preferred any reference.
Yes, madam. So
They have-
therefore,
It is lapsed.
yes, madam.
They were legally, they are entitled for. There is no doubt about it.
Yes, ma'am.
But since they have not preferred any reference petition, whether they can come by way of writ petition and obtain the same order. They should have referred, they have not done it.
Yes, ma'am.
That was their statutory provision under the act. Now whether after the lapse of time, when they have accepted the award, they may be. Because they doesn't have anything with regard to their earlier. Now, when the land was acquired, land was
2019.
acquired by notification of June 2018.
Right.
Right?
Yes, ma'am.
Now see the direction. Page number 46. Interest from the first day of the notification. In 2009, that is the reason no appeal has been preferred. We've been asking you, since the matter relates to public exchequer, we are asking you whether this order is executable. First notification of 2009 lapsed.
Madam.
That is when in 2018, the second notification was come. A similar judgment was passed by earlier an apex court. Right. Thereafter, that judgment was recalled and it was corrected, saying that since that proceeding was lapsed and a fresh notification has
Yes,
been
ma'am.
issued, from that period, though the petitioner, the persons who have been taken over the land or in possession, they are only supposed to pay rent. They are only supposed to pay rent. The actual award will be from the date of notification. The assessment of the land value has to be considered from the date of notification. Earlier proceeding might have lapsed.
Yes, ma'am.
So that it will come from rent. That was very specific by the apex court. You have not preferred any appeal.
No, madam.
Right, you have not preferred any appeal because direction was granted to
Yes,
the deputy commissioner to assess. But thing is this, you are in possession of the land, you have taken over the land. Now here is an order where the petitioners have not preferred in reference and obtain an order through a writ petition. That is why I am asking you whether this order is executable.
Madam, as I have already submitted, madam, my limited understanding is, madam, it is not executable. It's because, madam, there is a specific provision by which it has to be, madam, executed. So therefore, madam, in a specific term, it means, madam, it is judgment in, madam, per career, madam. So therefore, contempt is
Yes,
not.
My lord. In regard of
Kindly
the,
read
my
section,
lord,
kindly read section 64 of the 2039.
my lord, in regard of the,
Kindly read.
yes,
We cannot go beyond the law,
yes, yes, my lord.
right?
Yes, I will never.
Had we been in the law, we will do everything.
Yes,
But if
yes.
we cannot go beyond the law.
Yes, yeah, my lord.
Kindly read.
Section,
64.
reference to the authority. Any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the administration of the authority. As the case may be, whether his objection to be to the measurement of the land, the amount of the compensation, the person to whom it is payable, drive the rehabilitation and resettlement under chapter 5 and 6, or the information of the compensation among the person is interested, provided that the collector shall, within the period of 30 days from the date of receipt of the application, make reference to the appropriate authority, and provided further that where the collector failed to make such reference within the period of so specific, the applicant may apply to the authority as the case may be. requesting it to direct the collector to make reference to it within the period of 30 days.
Go ahead, can you read?
The application shall state the ground on which the objection to the award is taken. The provide that every such application shall be made if the person making it was present or represented before the collector at the time when he made his award within the 6 weeks from the date of the collector award. In other cases, within 6 weeks of the receipt of the notice from the collector under Section 21 or within 6 months from the date of the collector award, whichever period shall first expire. Provided further that the collector may entertain an application after the expiry of the said period within a further period of 1 year, if he is satisfied that there was sufficient cause for not filing it within the period of specific in the first provision. My lord, this has been actually discussed before the court, my lord, and this court has observed that if there is a statutory benefit which is entitled, then this court may have the right to interfere into the court matter.
In that particular provision,
My lord,
there
here
is specifically the act provides that
my lord, I am not bringing the Supreme Court citation, but there is in
you go through the judgment again, once again, the judgment of the Supreme Court where it is the
and
three judges.
I have not my lord, no.
Please come to read that provision again, section 64. Objections may be with regard to what? To the measurement of the land, that is one. Then the amount of the compensation.
My lord.
So the amount of the compensation also includes the interest. What is the definition of compensation? What is the definition of compensation in this act? Come to page number 9. Read I. Then read 1. Kindly read.
Amount of compensation which include the solution, any enhanced compensation order passed by the Land Acquisition and Rehabilitation Settlement Authority or court, and interest payable thereon, and any other amount determined as payable to the affected families by such authority or court. Deemed to be
So compensation includes the interest. You have not preferred any reference petition.
My lord,
You get it by a second door.
that is not my lord. My humble submission, my lord.
Your order apparently will not consider this.
My lord,
Because there are judgments of the apex court whether this.
my lord, this may be. I will bring my citation regarding this, my lord. If my lord, I may be allowed to give tomorrow, my lord. Yes, my lord.
Tomorrow. Please this contempt petition along with the records of WPC number 97/2021 disposed of on 14/05/2024.
One more, my lord. Appeal has been filed, actually.
Next.
Yes.
Mr. Kato,
My lord.
you should not allow these things to happen.
My
And
lord.
also telling the government and councils.
Yes, my lord.
Unless you can SSD code. It's
Very sorry,
meaningless.
my lord, my lord, while disposing of the matter, my lord, my name is also not reflected.
You do not know.
Yes.
The thing is this. Every it is the duty of the court officers.
Yes.
To SSD code to
Yes,
adjudicate.
my lord, admittedly, when, my lord,
Now it has come to your notice, Mr. Kato. We have nothing to say. Yes.
Yes, your lordship, I'm challenging the eviction notice
Let
issued
us
by
see
the
what the
superintendent
matter
of police, which is not in accordance with our Arunachal Pradesh Public Premises Act. May I read the petition?
That, Arunachal,
Honestly, but is public premises.
I think book number 4,
May I, Your Lordship?
just a minute. Arunachal Pradesh public premises. Yes, ma'am. What do you have to say?
Yes, sir. Earlier, Your Lordship, instruction was sought. I have received the instruction, Your Lordship.
Earlier instructions were sought for.
Yes, Your Lordship.
When?
When the matter, 22/4/2025, Your Lordship.
Hmm.
State to obtain instruction, Your Lordship.
You have the instructions
Yes,
with
Your
you?
Lordship.
Can you give it to us?
Paragraph 5, Your Lordship. Paragraph 1 and 5.
Pursuant to the order dated 22/04/2025. MS Pubi Pangu, Government Advocate, Arunachal Pradesh. Placed a copy of the Gazette notification dated 30/06/2016, issued by the Chief Secretary, Government of Arunachal Pradesh, Itanagar, published in the Arunachal Pradesh Gazette Extraordinary on 18/10/2016, whereby the Superintendent of Police, Commandant of Arunachal PBN, AAPBN, and IRBN, Principal PTC, as a state officer. In addition to the AIGP of Police Headquarters, Itanagar, was earlier notified as a state officer for the land and premises in occupation of the police department all over the state by notification/order dated 14/10/2009. As such, the Superintendent of Police, Tirap District, Konsa, has the power to act as an state officer under the Arunachal Pradesh Public Premises in bracket Eviction of Unauthorized Occupants bracket close Act 2003. List tomorrow, along with the records of WPC number 81 bracket AP 2015. Ms. Prabhu, place it tomorrow.
Tomorrow you're not safe. You're not safe. Maybe it's
Keep it with
better
you.
this one. 9th.
No, we are asking for an old repetition.
Okay.
That's why it will be listed tomorrow along with that repetition.
Okay.
Mr. Devi, take up tomorrow.
Bless you.
Place us those documents tomorrow, Ms. Prabhu. Place us those documents tomorrow.
Item number 3, may it please your lordship.
Yes.
Your lordship, the petitioner is the entity established by in state of Arunachal Pradesh by state legislature, my lord. It is challenging the vires of UGC regulation, and in the alternative, prayer is, my lord, exemptions be granted for running distance and online mode course, my lord. My prayer is at page 48 of my petition, my lord.
Just tell us one thing.
Yes, my lord.
You are in a university in the which place? Registered where?
Here, Arunachal Pradesh, my lord. Your lordship will find the document at page. Lordship will find that document at page One 110, my lord. And at page 111, my lord, first act section, my lord. This act may be called and two, it shall come into force on such date, state government of Arunachal Pradesh may by notification the official gazette appoint, my lord. And I have got the UGC recognition at page 127, my lord. One 127, my lord, will find the UGC recognition, my lord. Page 127, annexer P5, my lord. And my lord, I applied for permission to start open and distance learning program. In fact, since 2012, I have been applying, my lord, time to time. And for one reason or the other, UGC has not been entertaining my application, my lord. Earlier round, my lord, I have been before Delhi High Court challenging the decision of UGC, my lord. But
6th February, Lord.
6th February, my lord. But Delhi High Court now has declined to entertain the writ petitions which relating to the entities which are established outside NCT of Delhi, my lord. And that is why we are before your lordship.
That is P44.
Yes. We have two grounds, my lord.
Yes, please.
The lordship will kindly see the letter, my lord, impugned letter at page 106, my lord.
Yes.
On this is the letter, my lord. UGC has notified, paragraph 1 at page 106, my lord. UGC has notified University Grant Commission Open and Distance Learning Program and Online Program Regulation 2000 on 4th September 2020 in the Gazette of India. Subsequently, the first and second amendment in principal regulation have been notified on 1st July of 2021 and 18 July 21, respectively, my lord. Now, regulation 2, my lord. These regulations shall apply to institute referred to in sub clause F of section 2 of University Grant Commission and institution deemed to be. Paragraph 4, my lord, is relevant paragraph. Eligibility criteria for recognition program under ODL, that is Open and Distance Learning, and online mode is specified in Regulation 3 and Regulation 3BB of UGC Open and Distance Learning Program and Online Program Regulation 2020 and its amendment, which is as under, my lord. Open and Distance Learning mode, any higher education may apply for offering program through the Open and Distance Learning mode, which fulfills the following conditions. Namely, small Roman 1 shall be accredited by National Assessment and Accreditation Council within minimum score of 3.1 on a 4-point scale or having rank up of top 100 in university category of National Institution ranking framework for at least 2 preceding years at the time of the application, my lord. So these are the two requirements which have been incorporated in the regulation, which was 20. And online mode, my lord. Any higher education may apply for offering program through online mode, which fulfills the following conditions, my lord. First, at least in existence for 3 years and shall be accredited for National Assessment Accreditation Council for minimum 3 and 4 years, my lord. Accordingly, the higher HEI may apply online for approval of open and distance learning program or online program as a dual mode, provided that HEI fulfills the condition provided and stipulated by University Grant Commission, Regulation 2020 and its amendment as and when as and when the applications are invited by UGC, my lord. So this is the letter by which rejection has been given to the petitioner, my lord. And may I take your lordship to the regulation, my lord?
Just a minute, just a minute.
Yes.
Well, this university was established.
Yes, my lord.
What we are not getting is that it has the to be under the control of the UGC.
Your Lordship,
There
that paper your Lordship will find, document your Lordship will find at page 127, my lord. Annexure P5.
No, 127.
Is the letter of the UGC, my lord, recognizing.
But where is in the act of the university that it has to be established only after the having the approval of the UGC?
Because that comes under section 2F of UGC Act, my lord. That comes from UGC Act because it's a central legislation under entry 66 of list 1. So they get, the state entities get the right to start the education once they get the approval, my lord, and that your lordship will find reference into, if your lordship will find that reference at page 127 F, my lord. First line, my lord. In first paragraph of 127. I am directed to inform UGC has received act of the state legislature of Arunachal Pradesh, wherein Venkateswara Open City, Itanagar, has been established wide notification number so-and-so dated 15th June 2012 in view of the establishment of so-and-so. The name of the institute has been included in the list maintained by UGC on its website on so-and-so, my lord. Because the regulations, they are Supreme Court judgments which are clear that we have to abide by and follow the regulations. Then only we will be, the institute will be, state institute will be authorized to grant degrees, my lord, and they will get recognition under the UGC Act, my lord. So those regulations are binding on the state institutes, my lord. And the challenge here is, my lord, twofold, primarily twofold, that the requirements under 3A of the UGC regulation are onerous and arbitrary. One paragraph, if your lordship may kindly see in my pleading also, page 33, my lord.
Yes.
And my pleading, your lordship will find at page 33, small Roman, the Roman 52, my lord, second paragraph at page 52, my lord. The respondent UGC also reiterated it's mandatory for the higher education institution, page 33, my lord.
Yes.
The second paragraph. It is further submitted that in the said letter, the respondent UGC also reiterated that it is mandatory for higher education institution to fulfill provisions as stipulated in UGC Regulation 2020. However, in this regard, it is submitted that there are several institutes that despite not having valid NAS accreditation 3.124 or accreditation at all, as required under regulation of 2020, have been granted permission by respondent UGC, thereby running open and distance learning courses successfully. It is pertinent to mention that Odisha State University, despite being established in 2015 without NAC accreditation or NIRF ranking, has been running successfully and implementing ODL and online mode. In this regard, it is further submitted that a few institutes such as Nalanda Open City in Bihar with C grade, Dibrugarh City and Krishna Kanta Handik State Institute, Assam, are running the courses in ODL mode with NAC accreditation plus B++ and B+ grade, which is much lower than the score as required under Regulation 2020. Similarly, as per amendment brought in the year of the UGC Regulation 2020, for every new a higher education institution has to apply fresh for NAC accreditation and NIRF ranking. However, there are certain institutes such as Ravindra Bharati University have had not its NAC accreditation updated since 2016. So, my lord, I am on both grounds, discrimination, and I'm praying, my lord, that notice may be issued so that UGC may file the reply that the virus of the regulation. And at this point of time, I'm not praying for any interim relief, my lord, in this matter. Because two impugn orders are there, my lord, at page 106, Annexure P2 and P3, my lord. And alternatively, my lord, they have the power, UGC has power to exempt also, if I can place that regulation, my lord, which is page 53, sub-regulation 3, my lord.
What is your accreditation?
And they are not permitting, the UGC is not
What
permitting.
is your accreditation? What is the accreditation of this?
Accreditation, because I have, I do not have accreditation, my lord. The requirement of the regulation is that I have to run the course 3 years, then only I can go for accreditation, my lord. So
You have not yet started the course.
no, because if I can't start the course without the permission of UGC, my lord. First, I have to get the permission, and for permission, what they say, you should have accreditation, my lord.
No, it is very clear.
You also kindly see the regulation, my lord. Kindly see the regulation at page 53.
Before that, you come to the page number 127.
Yes, my lord. This is the UGC letter recognizing.
Read para 2 and 3.
Yes, my lord. The inclusion of the name of UGC in the list of universities maintained by the UGC does not itself allow the university to make admission in its program. This may be done after creation of required academic and physical infrastructure facilities, including library, laboratories, and appointment of teachers and supporting staff as per norms and standards laid down by UGC statutory council concerned. 3. University is now requested to submit detailed information in enclosed format, along with the supporting documents duly attested by the registrar of the university within a period of 3 months from the receipt of letter. The format is also available to UGC in website, my lord. And kindly see the rejection letter at page.
Read page 129, para 6.
Yes, my lord. Yes, the university is required to follow UGC Establishment of Maintenance of Standard Private Cities Regulation 2003 and other regulations issued from time to time posted on UGC website. I have been following.
Do you comply with these provisions?
Yes, I comply with this requirement. The rejection is not on this ground, my lord. If your lordship, I place the impugn rejection letter at 1st April 2020 at page 106, my lord.
Certificate also which allows me to give scholarships and degrees.
Page 106, my lord.
Yes.
And this is the request, subject, my lord, request of Venkateswara Open City to apply online for approval of open and distance learning program as a dual mode university. Now, your lordship may kindly mark dual mode university. What they say is that there are 2 types of, one is that conventional teaching as well as open and distance learning mode. So far as open and distance learning mode is concerned, 3A and 3B requirement is not there, my lord. Kindly, with reference to your letter number dated 27th February 2024 on the above subject matter, I am to inform you as under UGC has notified University Grant Commission Regulation 2020 on 4th September 2020 in the Gazette of India. Subsequently, so and so amendments have been carried out, my lord. These regulations shall apply to university referred to under clause F of section 2 of University Grant Commission and institution deemed to be universities. Now, 4, my lord. Eligibility criteria for recognition of program under ODL and online mode is specified under Regulation 3A and 3BB of UGC Open Distance Regulation and its amendment, which is as under, my lord. Now, this is the requirement, my lord, that you have to have NI and NAC accreditation minimum 3, my lord. And I have placed the material that none of the universities are having this kind of rack, and then only I am eligible to apply. Online mode also, my lord. Accordingly, higher education institution may apply online for approval of open and distance learning or online program as a dual mode university, provided HEI fulfill other conditions provided in stipulated in University Grant Commission regulation and its amendment as and when invitation application. And then, my lord, kindly see 23rd next impugn 108 next impugn letter.
Yes.
Small Roman 1. This office-wide letter number dated 1st April 2024 intimated at the eligibility criteria for recognition of programs under ODR or online mode as provided under Regulation 3A and 3B. However, HEI-wide letter dated 15th May has informed that unless a university runs its course for 5 years, HEI may not be able to apply for NAC accreditation in terms of eligibility criteria laid down in NAC manual. Additionally, a minimum 3 batches with 3 years of running courses will make university eligible for accreditation in NIF ranking, my lord. So, if I take your lords, kindly take your lordship to the regulation, my lord, the problem which we are facing with regard to regulation, and that is why we have challenged the regulation virus of 3A and 3B at page 53, my lord, is the regulation, my lord.
Why have not implemented Ministry of Human Affairs?
I will implead, my lord.
Higher education.
I will implead, my lord, because we
Otherwise, it is not possible.
Yes, my lord. Your lordship is right. Your lordship is
So
absolute.
first implement that party, then we'll consider.
Yes, my lord. I will implead the
Union of
Yes,
India party.
Yes, I will implead the Union of India also party, my lord. Because this is a
First implement,
regulation.
then we'll consider. You first
Yes, my
implement.
lord.
It is
I'll
important.
implead. Yes, my lord. I'll do that, my lord.
You
Kindly
have
give me.
made only UGC party.
Oh, the reason, my lord, probably is because
You
that.
pass
only-
necessary order.
But
You
it
first
is,
implement.
I will implead, my lord. We will
Since
implead.
you are in Arunachal Pradesh, file a one-line application for implement of the Union of India, the Human Rights Affairs and the Higher Education. Then we'll consider.
Yes,
It is a
my lord.
necessary party.
Yes, my lord. Kindly give 1 week
And the
time.
prayer of the council for the petitioner. Matter is adjourned for today. And allowed to file appropriate application for implement of necessary party. We are not saying anything. This matter.
We'll implead the state government also, my lord. We will implead the
It's
state
up to you
government.
because it's a act has been passed by the state government.
Yes, my lord. We will implead the
Otherwise,
state
it is-
government also.
We are not saying anything. File it. Okay, it will be listed only after filing such necessary application.
Yes, my lord. Grateful, my lord.
Obliged, my lord.
Yeah.
Yes, Mr. Secretary.
Yes, Mr. My lord, here, the petitioners are challenging the, my lord, notification, my lord, whereby, my lord, the petitioner's land has been converted to reserve forest, my lord. My lord, there is a proposal for construction of double laning of the road in between, my lord, Blaze Paya and Corona, my lord, and for which, my lord, land acquisition notification was also issued, my lord, for double laning of the road. My lord, after the issuance of the land acquisition notification, my lord, there were, my lord, joint verification reports and the land dispute, my lord, regarding two claimants, my lord, including the petitioner and other sides, my lord. There and a minutes of the meeting was held, my lord, between the land owners to settle themselves, my lord, but that could not be settled, my lord. Lordship will find at page 69, my lord. My lord, before that, my lord, kindly see the land acquisition notification, my lord, at page 62, my lord. Page 62 is the land acquisition notification issued on 9th July 2021, my lord. Thereafter, my lord, bills were prepared, my lord. And before passing of the award, my lord, there were dispute between the two parties, my lord, including the petitioner's clan, my lord. For which, my lord, a meeting was convened by the deputy commissioner to settle the matter, my lord. Lordship will find at page 69, my lord.
Mr. Saikia,
My lord.
when the Gazette notification has been published, you cannot say that it was published in the year 1998. Now you cannot say that it has come to your knowledge in the year 2023 when it was brought to the notice of the court.
My lord,
That
even my
cannot
lord,
be a term.
assuming my lord, even the district deputy commissioner, my lord, doesn't have that knowledge that the land falls under the my
Maybe
lord.
that is a different issue altogether. The forest department has brought it to the notice of the deputy commissioner.
My lord,
So-
that's why my lord, it may, my lord may like to examine the matter, my lord. My lord, because my lord, immediately, my lord, after that, my lord, disposal of the a direction given by this, my lord, this honorable court to dispose of the writ petition, my lord. Only after disposal of the, my lord, representation in terms of the, my lord, order passed by this honorable court, we came to know that, my lord, the land is, my lord, declared as a reserve forest, my lord. We immediately, my lord, filed RTI applications, my lord, regarding the, my lord, lordship will kindly see the.
Already there, it was published in the Gazette of Arunachal Pradesh way back on 27th of April 1998.
My lord.
Right?
My lord.
So how many years back?
So almost, my lord, more than 20 years, my lord.
More than 20 years? We are in 2025 May.
May, my lord.
So?
So, my lord, my respectful submission is, my lord, there is no delays because.
27 years back it was notified.
Yes.
Can we interfere now?
My lord, to my respectful submission, my lord. So.
It is in the Gazette notification, sufficient. What else you need?
No, my lord. The Assam minor forest regulation minor of 1891 provides certain minor
Tell us,
procedures.
Mr. Sekar, which procedure has been violated?
My lord, I have given in my lord page, my lord. Kitna? Page my lord 9 onward, my lord. Because RTI says, my lord, in the reply, my lord, no records are available. My allegation is
Section, that was the time, the different. So tell us.
my lord, page 9, my lord, these are the my lord provisions violated by the authorities, my lord. May I read, my lord?
Read page 93.
My lord?
Read page 93.
93, my lord. My lord. For the area 184 square meters was declared as Digaru Reserve Forest under Lohit district. Arunachal Pradesh by notification dated 8 June 1971 under section 17 of the Assam Forest Regulation 1891. Read with section 3 of the Northeast Frontier Agency's construction of reference to the State Government Regulation 1965, where some errors detected regarding the area of the said reserve forest in existence of the Hekuliang village, now in exercise of the power conferred by section 17 of the Assam Forest Regulation 1891, read with section 3 of Northeast Frontier Agency construction of reference to the State Government Regulation 1965 as adopted and modified by the Northeast Area Regulation Arunachal Pradesh adoption of law order 1972. The governor of Arunachal Pradesh hereby pleased to amend the boundary description of Digaru Reserve Forest notified dated 8 June 1971 for 184 square kilometer area with the approval of the Government of India Ministry of Environment and Forest dated 28 November 1996 declared that the land in described schedule here to Telvi Reserve Forest from the date of its original notification.
You have heard about Kaziranga National Park? You have heard, right? There are new annexations in various parts, even in Bishanath Sarili, even in Nagaon. Right?
Yes, sir.
So
there are
certain provisions have to be followed, no doubt. But the basic fact is when you demarcate the land or you enhance the land, the certificate, this you have to obtain a permission from the Union of India.
Yes, sir.
Here, this notification was published after obtaining due approval from the Union of India on 28/11/1996. Of course, you have made a party. But thing is this, after these so many years, can it be unsettled? After 27 years of that notification, can it be unsettled?
To my respectful submission, maybe my lord. Because my lord, even
The right of easement only cannot be unsettled. Tell us.
my lord, that my lord,
This issue cropped up earlier in a case in Mizoram, where there was certain hydroelectrical project. There was a river flows down. Then some people started asking for compensation for their land. Lusai district was under Assam at that point of time, before the establishment of Mizoram. There, the notification of the government of Assam under the forest department was very clear that on the both sides of the river, certain meters were clarified to be considered as a forest land. Right? So the people were unaware because that notification was published while the Lusai district, Lusai Hill district was under Assam. It was not a Mizoram. And then that notification of the forest department was placed by the Union of India. And it was found that the government of Assam, while issuing that notification, because earlier it was that whatever the meters on the both sides of the river, and it was only with the approval of the Union of India and the records that was on the forest department, now only environment and forest department. There they clarified. And now that position cannot be unsettled after so many years. So people who were there are asking for land acquisition compensation for their land taking over for the purpose of hydroelectrical project. Rejected. This is a decision already reported.
But here, we had
And there
also,
was no settlement, right? There are also forest land settlement. There are some forest dwellers who are given settlement in the forest. There have to be considered, anything is there, but there was no such forest dwellers settled in those forest lands. Here it has been notified 27 years back. Now you are asking for compensation. Now you are asking for, because the 2 lane has been, it has been to the 4 lane now. So it has been with double lane, whatever. So the compensation has to be paid.
Well,
It will be
in
covered
fact-
by the decision of the particular decision of the adjournment, finished.
Right.
Go through those provisions, simply come, see, you have a right to argue before the court. But before that, you have to establish your right, that you have this right. Now, this notification of having this particular land within the forest department to the 2020, 18, I believe. 2019. It was in the 2018. 1998.
98, madam.
So from 98, approval of the government of India was in 1996 November, where you will have the right.
Well, still we are, my lord, cultivating in that land, my lord.
See, that is illegally.
My lord,
Even if you are doing something after 1998 April, 27 April, it will be illegal. But how will you have that right? Go to the judgment of the Isol bench, you'll know very well. It is reported in the ZLT. Go through it. What is the clarification made? Because in those cases also earlier, there are numbers of writ petitions. In some earlier writ petitions, some of the honorable judges without, because these facts were not produced because they were fighting against only the state government. State government was not aware of that notice, necessarily. It was by the Assam Forest Department, it was published. While the Losai Hills district was a part of Assam, right? But here it is by the Arunachal Pradesh itself.
but
There also deputy commissioner was not aware.
Well,
Only in one of the case,
well,
I think I
for
was in that
settlement,
case.
my lord, deputy commissioner is the forest officer.
Cannot do that. Cannot do that when this land is already notified to be a forest land in the year 1998 April. How do you do it, Mr. Saikia?
Well, may I humbly pray that it is notice may be issued, let them.
We will not issue notice. First, you go to the judgment of the Honorable Isol bench, you go through what is the finding therein. And here is also, first of all, it has to be maintainability has to be counted. Where will you say it? This is a notification, gazette notification. It has come to your notice in a particular case, will not help you.
My lord, so my lord, I humbly pray that let them, my lord, object to this, my lord, maintainability of the, my lord.
No,
by
not
petition.
to- at this stage, you will not do anything.
Because, my lord, in one of
See.
the earlier case of, in the state of Arunachal Pradesh also, my lord, where land has been, my lord, without following this procedure, my lord, this honorable court has said that, my lord.
This is a
notification-
case where, rightly or wrongly, 27 years back, this notification was published. Can you challenge it now to show that?
My lord, to my respectful submission, yes, my lord, because
So
only.
what, where is
for-
that? Some materials may not be available. You have to establish that those things have not been followed. Because it has the approval, other of the Union of India will not have approved it. They have to, what is the system of approval? It is in the Forest Act, what is to be followed, right?
Yes, yes.
Everything is there. Only then the Department of Forest will, or the Forest and Environment now will give the approval. They're very clear. What are the things when a particular land extension is made for inclusion of in the Forest Department or as a reserve forest, what are to be followed? Each and every document has to be complied, or even every order has to be complied by the state. Otherwise, the Union of India will not do. And that is the reason why this gazette notification has to be published. That is also the provision of the Forest Act, the Central Act.
This has been published under the, my lord, Assam Forest Regulation, my lord.
That is when thereafter there are notifications. That is why Assam Forest Regulation also comes under the main act. Forest Act is a very old act, right? That is why this gazette notification. Otherwise, there is no requirement of this. Why the Union of India's permission was required? Go through those provisions of the Forest Act, you will know. There is in fact in the Kaziranga extension matter, all these things has been discussed.
My lord, I'll try to lay
Can you
hand on
satisfy
those
the court
things,
will
my lord.
definitely pass an order in your favor. Why not? But you have to first satisfy your court. Take your time and see, go to the provisions, tell
Right.
us when.
Next week, my lord. I will
Who is
be-
for the Union of India? Heard Mr. Arseka, counsel appearing for the petition. NMS, Pangu, Government Advocate Arunachal Pradesh for the responding numbers 1 to 7. And Mr. You are CGC,
No, I'm on behalf of MCAT.
Learned Counsel on behalf of Mr. M. Katul and the Deputy Solicitor General of India for the responding number 8. Petitioners hearing have challenged the notification dated 06/04/1998 issued by the Department of Environment and Forest, Government of Arunachal Pradesh, published in the Arunachal Pradesh Gazette Extraordinary on 27/04/1998, by which, after obtaining due approval for the Government of India in the Ministry of Environment Forest, New Delhi, file number 86/96-FC, dated 28/11/1996, comma. Declared an area of 204.45 square kilometer of Lohit district of Arunachal Pradesh as Digaru Reserved Forest. The contention of the petitioners herein are that while declaring the land measuring 204.45 square kilometer of Lohit district of Arunachal Pradesh as Digaru Reserved Forest, the provisions of Assam Forest regulations, as well as the provision of Northeast Frontier Agency, don't write. Assam Forest regulations have not been complied with. This writ petition was filed, has been filed. This writ petition was filed on 03/05/2025. And the contention of the petitioners are that they came to know about the said notification of the Arunachal Department of Environment Forest dated 06/04/1998 very recently, when the Deputy Commissioner
After the disposal order, page 89, my lord.
Teju passed an order
In terms of,
on
my lord,
04/12/2023
23-1.
pursuant to an order which, what is the date of the order of the court?
Date of order is, my lord. 4/12/2023, my lord.
Date of the order 4/10.
No,
Sure.
no, sorry, my lord. This, my lord. 13/10/2023, my lord. Page 86, my lord.
13/10/2023
Page 86, my lord.
passed in WPC number 514/2023, where the Deputy Commissioner, Lohit District, rejected of granting ownership to the petitioners, considering the land involved as reserve forest land. We have written that Assam Forest Regulation, no? You write Assam Forest Regulations, no? 1891. As already noted above, the state government in the Environment Forest Department have issued the necessary gazette notification. We have account 2704/1998. And the claim of the petitioner at this belated stage. Claim of the petitioners in this petition at this belated stage after 27 years. Legally not permissible. At this stage, Mr. Saikia prays for some time. Learned counsel for the petitions prays for some time. To urge his case one again, to which the counsels for the respondents have no objection. List on 15th May.
15 May, man. Oh, no.
Number 6.
The lawsuit map. Wait a minute. Well, in this matter, as per the earlier order, we sought for the amendment and we have filed amended petitions today, and I have served extra copy to the respondent number
Mr.
2.
Moore and the counsel appearing for the petitioner submitted that petitioners have filed, petitioner has filed an additional
amended petition.
Filed an amended petition. Serving a copy of the counsel for the respondents. However, the copy of the amended petition is not available in the case record. The registry shall verify and shall incorporate the amended petition in the case record.
I've served to the
My lord,
private.
my lord, in this matter, we have filed an affidavit challenging the maintainability of the petition. Once we had filed this said affidavit, they came up with a prayer that they would like to bring about certain notifications on record, my lord. Now, my lord, the order dated 18/3/25, my lord, the second last order. If I may, my lord. Mr. R. Ingo, learned counsel appearing on behalf of Mr. S. Mao, learned counsel for the petitioner, submits that there are certain notifications issued by the government which could not be annexed at the time of filing this writ petition, and prays for time allowing him to amend the writ petition by incorporating the government notifications and subsequent notifications issued by the government. Prayer allowed. Now, my lord, the last order, my lord. Third paragraph, my lord. May I? The learned counsel for respondent number 2, 3, and 5, that would be us, my lord, Power Grid, has reiterated his plea of maintainability of the writ petition, qua the prayers direction sought in the writ petition.
We'll make it clear.
My lord, my humble prayer is.
We'll make it clear.
And my lord, the
such and such, no? When you have fixed, what is the date? Okay. It is made clear that before that, notice in this case was issued
My lord, 3124.
30-01-2024. And this petition is yet to be admitted. The respondent numbers 2, 3, and 5 have raised the question of maintainability of this writ petition. Next, you have. Before proceeding further with this writ petition, the maintainability of this writ petition shall be considered first.
My lord, 9th of June. 9th of June.
It is on 15th, I think, 14th or 15th. Any date fixed? I think it is fixed.
9th of June, my lord.
Not on 9th.
My lord, 19th of May, then, in that case.
You want 19th of May, Monday?
19th May or 9th of June, whichever my lord will be.
You, let it be, because let the maintainability decide first, then it will proceed. Okay. 19th of May,
My lord.
on the prayer of the council for the parties, list on 19th of May.
Extra copies of the amended.
There has been, Mr. Moore told me that has been served.
No, extra copies maybe. Amended, they have. served
You have
the-
filed amended writ petition.
We will serve.
Mr. Moore shall also serve the amended, but you have amended, there is no direction for amendment of writ petition.
My lord,
Only you are supposed to file the notifications and the government notifications. in
my
that
lord, what
regard.
they have done is they have
My lord-
changed the whole nature of the
We
writ,
have
my lord.
sought for amendment.
By which other amendment was allowed?
My lord, the second last order, 18/3/25, my lord. It was not,
Clear only the government notifications.
my lord, it was
So,
only to bring about the
Because
notification.
at the earlier, we have prayed under the Lara Act. So, but then once the notification, when we came to know about notification, then notification doesn't talk about the Lara Act. That's how we have to change on
But you
that.
cannot change the prayer.
My lord,
If the prayer is changed, right? The
Well,
amendment cannot be allowed.
Well, prayer is only, the matter issue is only for the payment of the compensation. Basically, they have already taken the possession of the land, but they have not paid the compensation. That is
What
the
is
only.
your prayer in the new amended writ petition?
In the prayer, Malat, is that
Have you changed the prayer?
they have.
yes, only
You
the
have changed the prayer.
land
In
acquisition.
that case, cannot be considered. When amendment can be allowed? To bring in certain facts. If the petition becomes very bulky or additional affidavit, instead of we go file one consolidated petition. But you cannot amend the writ petition as a prayer. Then you have to withdraw that writ petition and file a fresh writ petition.
Then
The characters of the entire petition will change when the amended petitions are, prayers are changed.
only, yes, we have changed the, earlier it was Lara Act, we have changed the electricity act.
No,
Malat.
that cannot be-
Then
That is the provision.
then Malat, then we will file fresh, Malat, then.
That will be better.
That will be better.
That's right.
We're liberty to file fresh,
At
Malat.
the present stage is akin to my.
See, otherwise, when the, that is what the secrecy. the
Yes,
plaint,
yes,
right? Plaint is what? It's very clear.
Yes.
You can amend without changing the prayer. The prayer changes, the character of the suit changes.
But I thought this is only for compensation, then only, then Malat, I may be allowed to
My lord,
withdraw
I hope you
and
don't have any
file
objection
fresh.
to that.
My lord, if I
Delete
may,
that order.
yes, my lord, if I may submit, they have come forward initially.
We have seen that
for the
tower has been
opposition.
constructed and then they want the compensation
Now,
with
my
delay.
lord, the factual position of law is,
Act is very clear.
Act-
There it is provided what kind of compensation to be provided.
my lord, only
And
surface.
not beyond that. So
surface
many
damage to
decisions
the
are
crop.
there. We have issued so many
And
judgments.
my lord, the appropriate forum for them.
There
My
is.
friend may exercise his
regulatory
right today
petition.
under 16(3)
Right.
is the district judge. So
Right.
if he comes up with a new writ also, my lord, end of the day, he will have to go down to that forum.
That is, that
So he may seek instruction if he has to that effect, my lord.
Let him file again, you object?
yes, yes, that's true, my lord.
Heard Mr. Rasmus, counsel appearing for the petition. And Mr. M. Dutton, learned senior government advocate, appearing for the respondent numbers.
4 and 6.
Okay, you are for Mr. Kato? Okay. Mr. Such and such, learned counsel appearing for Mr. Kato, deputy. So, DYSGI, right? For the respondent numbers 1. You are appearing for 1, 2, 1. Okay. You are appearing
My
for.
lord, I'm for 2, 3, and 5, my lord. Power Grid Corporation of India.
You are Mr. Khera,
My lord, NK.
Land Standing Council, Power Grid Corporation India Limited, for the respondent numbers 235. And Mr. Ann Rattan, Senior Government Advocate, Arunachal Pradesh, for the respondent numbers 4 and 6. Mr. Mao, Land Council, on instruction of the petitioner, prays for withdrawal of this writ petition. With a liberty to approach the appropriate forum for redressal of his grievances, to which the council for the respondents have no objection.
My lord.
Prayer allowed. Liberty so prayed for granted. This writ petition stand dismissed on withdrawal.
All right.
All right.
May I, Lordship? Lordship, service is not completed, Lordship. I think this matter is wrongly listed in the admission, Lordship.
Where is the act? Where is the regulatory order of authority? It is there in the Arunachal Pradesh Act. The act you are challenging, not challenging, you are asking for the regulatory authority, right?
Lordship, I'm not aware of the case, Lordship. Since conducting counsel, Mr. D. Soki is out of his station,
It
Lordship.
doesn't matter, we'll pass on. Water Resource Regulatory Authority Act, Arunachal Pradesh Water Resource Regulatory 2006. Which volume it is there? Any idea, Miss Gote? No, this is Arunachal Pradesh Water Resources Regulatory Authority Act 2006. The same way you can say, Kumbata volume of 2006 or where the start is. After 4 is up to 97. Volume better low has to sound. Purana volume like not on volume ketaman like this. This is (1994) like I said. Last row Purana 8, 9, 8, 7 in a can. This is for the power up to 1990. And at the bottom page to silo. This is up to 1990. After 1990, not 96. 6, 7, so 2000, 2006 Nine, yeah, 9 or about 10, 8, 9, 10, so even 2011 on studies. This is 2006. No, you're overholding. This is still 9, 8 and 9, so. Eight and 9. So. Into 9 out of 6.
We are in receipt of the Terra comments with regard to responded 1, 2, and 3. So. In this Terra also, they have annexed the national water policy on the 2012.
Santosh. By W. Read section 1(3).
Yes, sir.
You have section 1(3) on the left. Kindly read. Now read section 3.
Still come into force of it. On such that if it's the government may file a self-aided, appoint and different as may be appointed for different areas and for different sections of this area.
So there has to be an appointed date For that purpose, a gazette notification, a separate gazette notification will be required. This is the appointed date. By notification means the notification to be published in the Gazette of Arunachal Pradesh. Now read section 3. Section 2 is the definition. Read section 3. Again, you will get on the left side of the book. You will get detail. Read.
The state government's within 3 months from the date of the commencement of this by notification in the official gazette, establishment authority will be known as Arunachal Pradesh Water Resources Regulatory Authority. So
This act has been published sometimes on 15th of December 2006 in the Gazette notification. This act, but we do not know. Only you will be knowing if you have been provided with the information from which that this particular act has come into force, because this act will come into force from the appointed date. Whether the government of Arunachal Pradesh have issued any notification in that regard, we do not know. Now, within 3 months from coming into the force of this 2006 Act, you are supposed to constitute an authority, a chairman with 2 members, to be selected by the selection committee as provided under Section 5 of the 2006 Act, where the Chief Secretary is the chairman of the selection committee. Tell us whether the government have published any such notification, gazette notification, giving the appointed date of this 2006 Act. Unless an act is brought into force as required under Section 1(3) and Section 3 of this 2006 Act, it is a meaningless act. That instruction you give it to us by Wednesday, simple, that department has to tell us whether the Section 1(3) has been notified or not, whether Section 3(1) has been notified or not. That has to be, it is very specific, it has to be published in the Gazette notification. Act has been published, but what about Section 1(3) and Section 3 of this 2006 Act? Do you have that information with you? If you do not have, get the Gazette notification, copy of the Gazette notification. Unless it is notified in the Gazette, it is a meaningless, totally futile act. Published in 2006, almost 18 years back. So, for 18 years, we do not know whether it has been executed or not, whether it has come into the force or not. You got it? So, Section 1(3) and Section 3 has to be very clear. It has to be Gazette notification. Let us know by Wednesday. Don't delay the matter. You ask the department, they will tell you. If it is there, there. If it is not there, you do it. Finish it up. We'll pass an order that in terms of the Section 1(3) and Section 3, the government will do the needful. That's all. We cannot go beyond that. Right?
Lordship, let me take a proper instruction, because Lordship, this was being handled by one of my senior.
Doesn't matter. Doesn't matter. Just from that department, you just have the notification, whether the notification as required under Section 1(3) and Section 3 of this 2000 Act hasn't published or notified or not, whether it is published in the Gazette or not. That much only you require. If it is yes, yes, no, no. If it is no, we'll pass an order. Right? If it is yes, very good. That much is required, not much, only 2-line instructions. That is, you are fixing your day after tomorrow for your health. If you have not done, you can do it now. They have to verify the file.
Give me on 8.
You want on 8? Just a minute. We'll give you the date. No problem. We can have it on 8. You don't have a nodal officers who deals with all the departments so that you can have the instructions within time. See, nowadays your cases have been increased, not like earlier days. So you should have a nodal officer.
Especially this case is with regard to ALO.
No, no, no. Question of ALO, because the main department is, that's what I'm trying to get in. Let us see which department has issued it. The books are not giving the department notification, that is a difficulty. The notification is to be there. Whether it is in Water Resource Department or it may be Water Resource Department. We have not seen. Huh? Public Health. You will get it from the. Do you have any information? Public Health has issued it?
Yes, sir.
Then there will be a file number. That notifications you will get in the file number only. Get it from the VHC, okay. Have it on 8. No issues. List on 8. Enabling MS Executive Learned Additional Senior Government Advocate Arunachal Pradesh to place the relevant instructions in the matter pertaining to section 1 within bracket small 3 as well as section 3 of the Arunachal Pradesh Water Resources Regulatory Authority Act 2006 published in the that much will do. That much will do.
Let's see, one of the party, private respondent number 5, they have just filed their reply. Today only I have received this copy.
Just a minute. You are Mr.
Jiga Talorsi.
Definitely. But you have not found any rejoinder to the affidavit of the respondent number 2 and 3 also?
Yes, exactly.
Okay. The respondent numbers 3 and 4. Public Health Engineering and Water Supply Division alone filed their affidavits on 0209-2024 and the private respondent number 5 file his affidavit on 0105-2025. Petitioner is praying for some time to file rejoinder to the affidavits of the respondents noted above. Prayer aloud. Before it, right? Prayer before the prayer. The place was such and such. Okay. Then you write. Service of notice is complete on all the respondents. Issue rule. The petitioner shall file its rejoinder to the affidavits of the respondents 3, 4, and 5 on or before 26th of May, list for hearing on 3rd of June. Alleged lordship. Write their names, such and such. Ma'am, you are appearing for which respondent? 2 and 3 and 4?
1 to 4.
1, 2, 4. And put him, you are for 5. Yes.
Contender is appearing today, Lordship. I hope he has come with some instruction, maybe, Lordship. It's a contempt petition, Lordship. There was a specific direction from the court to disperse the, to deposit the amount, compensation amount.
Just a moment. Just a moment. It is the same appeal, Lilang. Is it the same appeal that is pending before the Supreme Court?
No, well,
It's this was.
No, it's because
I'm told, my lord, that has been disposed of.
where is the single bench judging? Where is the single bench judgment? Page number? This is division bench judgment. Where is the single bench judgment?
Single bench judgment, Lordship,
Which page?
page number. 60, Lordship. 60, 59, Lordship. Operating portion is at page number 63, Lordship.
Land was acquired under which process? Under which provision of law?
2013, Lordship.
Hmm?
2013 Act. Initially,
What is happening, Mr. Cotton?
assessment was done as per 2013. but
Whatever it may be, land was acquired under which provisions of the act? That's why we are asking you.
Lordship, Balipara Act, Lordship, frontier tracts, Zoom land regulation. Lordship.
Say
But then the
that.
calculation was done as per 2013 Act. Assessment, the entire assessment was done as per 2013.
Your assessment was made on the basis of what?
2013 Act, Lordship.
Hmm?
Lordship, the issue revolves around the rate of the cardamom, Lordship.
That rate what was, it was assessed on what basis? When the notification was issued?
Lordship, there was a notification fixing the rate of the cardamom, Lordship.
When the notification was issued for taking over your land? When the notification was issued for taking over your land? By which date the land was taken over?
Lordship, I'll just assess.
Notification, my lord, page number 60, my lord.
60.
My lord.
What is the date?
Date 10th March 2021.
Where is that? Where you are getting it?
Last person, madam. It is submitted that after the compensation was assessed by joint verification, a notification dated 10th March.
That notification is for what?
More particularly.
Where is this contempt petition? Along with the records of WPC number 32020221. Decided on zero 08092022, as well as the records of WPC number 291/2022, decided on 24/07/2024. Wednesday.
Mal.
Obliged.
Yep.
My lord, I am for the contender. I am appearing the first time for the contender. My lord, here the contender respondent has reinstated of the petitioner's LCs. Thereby, my lord, this contempt petition, my lord, in practice, since the contender has complied the order dated 3/2025 in WPC number.
Where is that? Where is that? You have a copy?
No, Your Honor, here it is, they have appointed copy. I have not been served copy, Your Honor. I have relied.
Where is the compliance order?
This is already registry in your account, Your Honor. My lord.
What are the direction which is appearing for the petitioner?
Lordship, even though petitioner have reinstated the service, but they are pending of releasing salaries since from 2022, 3 years. So my humble prayer is that 2 weeks maybe matter may be fixed on 2 weeks, after 2 weeks, so that respondent authority may complete the process of that. My lord, all the petitioner has already received their respective order. It is passed.
What was the order passed in 3/2025?
Yes.
Okay. You are Mr.
Entaro, Nabam Taro. I'm Antonio.
Planet Council appearing for the petitioners. What's your good name?
Entania, Nabam Tania.
Planet Council has entered appearance on behalf of the sole contemner. Matter relates to non-compliance of the order dated 0303 paragraph was right, no? 03032025 passed by a coordinate bench of this court in WPC number 19/2023. Non-compliance and willful disobedience on the other coordinate bench court in WPC number 19/2023. This court earlier on 02042025 issued notice to the sole contemner on finding that the deputy commissioner Kradadi district by its speaking order dated while issuing its speaking order dated 26/03/2025 in pursuance to the order of the court dated 03/03/2025 in WPC number 19/2023 did not comply, did not consider the office memorandum dated 20/01/2025, office memorandum dated 20/01/2025, as well as the notification dated 20/10/2017 issued by the Department of Administrative Reforms, Government of Arunachal Pradesh, White Memo number AR-68/2010, and rejected the claim of the petitioners. However, after the order of this court dated 02/04/25 passed in this proceeding, the Deputy Commissioner Kradadi District, Palin, white number KD/ESTT/ALC-15 within bracket volume POL dash all capital POL dash capital Roman 2 bracket close /2023 dated 23/04/2025 passed a fresh order as follows. This, it is there in the file itself, no, in the top. It is already marked here. Okay. As the sole respond contender, I, the Deputy Commissioner, Curiae District, Palin, by its order is it 23042025. Complied with the order, it is 03032025. Passed earlier by code in advance in WPC number 19/2023. The court found that the sole respondent / contender did not commit any contempt of court. As such, this contempt proceeding, this contempt proceeding being without merit stands rejected for the reasons above. The notice of contempt issued to the sole contender earlier on 02042025 is hereby recalled. However, it is made clear that if the respondents, if the petitioners are still aggrieved by the non-compliance of the, still aggrieved by the said order of the Deputy Commissioner, Curiae District, Palin, dated 23042025, may approach the appropriate forum for their or redressal of their grievances. Yes. Okay.
Nice.
It's closed.
Nice.
Yes, Mr. Agarwal. Accounts have been freezed. Why? Yes.
Is it, yes, may I please, your lordship?
Yes, yes. You are representing the ICICI Bank.
Yes, your lordship, I am representing ICICI and page number 27 is the notice.
Who is representing HDFC Bank?
No, your lordship, I have no instruction to represent your lordship till time.
Notice at page 23.
27, your lordship, typed copy. 26 is the main original copy.
Yes, ma'am. What is the instruction you have?
No, sir, even in this matter, I was not handling this matter. Today only I have come to know, and then also we have received instruction in the form of reply. So I pray that we may be given some time to file that.
Okay.
And also in this matter, Lordship, I feel the PPs they
Should be
their part.
incorporated.
Yes,
Right.
because all the communications also they have given to the, since they are used to giving to PPs.
Yes.
they have-
We'll clarify.
Yes, there should be the party proper representative. There will be the proper representative.
From this petition filed by the petitioner, it can be seen that the account of the petitioner, accounts of the petitioner have been freezed on the basis of a communication issued by the officer in charge of Naharlagun Police Station arising out of Naharlagun Police Station case number 40/2025 under sections 314/316/516/11/61/61 that somehow have not written properly. 61/316 within bracket 5 of, I'll make it again. Police station case number 40/2025 under sections 318 within bracket 4/316 within bracket 5/61 within bracket 1/61 within bracket 2/3 within bracket 5 of the BNS. However, the petitioner hasn't made the public prosecutor has not made the officer in charge. Oh, you have made. Doesn't matter. You write one line. The petitioners shall serve an extra copy of this writ petition along with the annexes appended to the public prosecutor Arunachal Pradesh representing respondent number 3. Registry shall reflect the name of public prosecutor Arunachal Pradesh in the cause list for the respondent number 3. List on 7th. We'll have it on 7th.
Your lordship, my presence may be.
Yes. What is it? Have you filed Okalatnama?
Yes, your lord. Today we will file. We have already sent, but it could not reach your lordship. So by the next date we will.
Okay. Day after tomorrow it's been listed.
Yes,
it
your
will be
lordship.
listed on 7th. By that time you file your Okalatnama.
Yes.
Okay.